Good afternoon, good afternoon, good afternoon, and welcome to Tay Biz TV, man. We are live in full effect right now. We're about to go ahead and get this party started. I'm watching Law and Crime right now to see when it gets started here. It's supposed to get started at 12:30. It is 12:32. For some reason, I'm not too surprised that they are a little bit late and behind, but we are here in the building. We are going to do this. And also, we're going to talk a little bit about Brian Steele this morning, because Brian Steele this morning was in front of the Supreme Court of Georgia. Yes, he was in front of the Supreme Court of Georgia this morning, and he was at an oral argument hearing before the Supreme Court for the case of State versus Riley. And Thugger Daily, shout out to Thugger Daily once again. He had the live link for the hearing. I was able to catch some of it this morning, but I believe Kat Williams also has the video on her channel. We're going to go ahead and take a look at it, and I'm going to give credit to Kat for the video as well. And so we can get started with that. But we're going to go ahead and kind of like talk about it a little bit, because it's very interesting actually, that this case in particular, because it's kind of similar to what Brian Steele mentioned to the Superior Court of this trial for YSL. Remember, there was a motion that Brian Steele gave to the courts about the fact that he argued the fact that there was a miscategorization of the RICO indictment, and the fact that's even labeled RICO is wrong, and so that's basically the same argument that he had this morning, defective indictment argument. You know what I'm saying? So we're going to actually look at the State versus Riley situation, the whole case. This is actually back in 2015 under Paul Howard's administration. And so when this case actually took place, and then we're going to go ahead and take a look at the actual hearing this morning. And I'm going to show you, I actually have a little snapshot, a little screenshot. I'm going to show you actually the information, and it has who representing who. And so when it comes to the appellate court, it's a long list of different, attorneys or whatever. And then when it's time, and then when it says who is representing Riley, it just says Brian Steele. All right, here we go.
We'd rather continue working on those than even attempt to start addressing
Shout
that.
out to She Lee in the building.
Yes, Your Honor. We're going to wait to file our motion in limine.
I'm so happy that you're streaming today. I appreciate you.
We want to make sure we're not wasting.
Shout out to Chill
Okay, I appreciate
in
that.
the building as well. Says please hit the like button as you come on in.
Sure.
And I meant to bring this up earlier.
Let's go, y'all.
Sorry. I have a client that's scheduled for a bond hearing at 2. I have another attorney coming in with the court's permission to sit with Mr. Stillwell briefly for about 15 minutes while I conduct a bond hearing, if that's okay with Your Honor. It's on Zoom.
Is it okay with Mr. Stillwell?
Mr. Stillwell, he usually works with me.
Did he say yes?
So it's fine with you if he takes a brief break? Okay. Well, obviously hurry back, because you seem to be the main person making a lot of the evidentiary arguments. So
Yes, Your
we'll
Honor.
miss you while you're gone.
All right, thank you.
All right.
Shout out to Max
Anything
Shark,
else
Mad
from
Max.
anybody? I know, Mr. Matthews, you had let me know after we went off the record yesterday in the presence of the state as well, that you wanted to circle back on one of the items of evidence that we had reviewed yesterday. So you can go ahead and do that.
Would you like to do that now?
Sure.
Okay. All right.
That's discreet. We can go ahead and get that taken care of.
Silver Fox in the building.
Judge, we're before this court
representing Mr. Marquavius Huey on this matter. There's an intrinsic act that was listed in the state's notice to us back in November of last year concerning item 43, which is an intrinsic act that the state is alleging should be coming into this trial. Your Honor, that particular intrinsic act stems from a November 30th, 2021 alleged incident. It's a police chase, Your Honor. In that police chase, the state are presenting to the court that this intrinsic act is somehow connected to this case and should come into evidence. That's the issue before the court. The rule that I'm asking this court to apply in this particular case obviously deals with intrinsic acts and what are the requirements for them to come in. As the court is aware, and I've cited for the court Murphy versus the state, 354 Georgia App 560. It's a 2020 case, and the case stands for the proposition that in order for intrinsic evidence to come in, evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions as the charged offense. So the charged offense in our case, Your Honor, is stemming from an October 1, 2020 alleged armed robbery of a deceased individual, Gary Holloman, from October 1, 2020. So it is not meeting the threshold of being an uncharged offense that is arising from the same transaction or series of transactions. Number two, for consideration for this court is whether or not this particular alleged evidence is necessary to complete the story of the crime. Again, we're talking about a November 30th, 2021 police chase that is not necessary to complete any story of any alleged armed robbery of Gary Holloman on October 1st, 2020. It's not necessary to have the state provide more information in order for them to complete the context of their story. Number three, for the court's consideration as adopted from the 11th Circuit, is whether or not this particular alleged conduct as an intrinsic act is inextricably intertwined with the evidence regarding the charged offense of the armed robbery from October 1, 2020. According to the court in Murphy, evidence of other acts is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. So it's not inextricably intertwined from the standpoint of the November 30th, 2021 alleged this police chase where they're alleging that Mr. Huey was involved in this police chase. There's nothing about the October 1, 2020 case that involves a particular vehicle that is supposed to be part of this police chase. So there's no connection there. With respect to the police chase itself, the vehicle was not apprehended. That's number one. The chase was ultimately called off. The identity of the driver on that day was never established through any apprehension. The vehicle eluded law enforcement. There were no admissions through any subsequent arrest that was made on Mr. Huey of any admission to even being a part of this police chase, being a driver in this car. When you look at the video, there's no photos of Mr. Huey operating this particular vehicle. There's no ownership information that would show that he actually was operating this particular vehicle on that day. And the vehicle is not the subject of having been used in this particular alleged armed robbery on October 1, 2020. So the vehicle is not a nexus to any of the charges. And so the vehicle would not make it necessary to complete the story of the alleged crime in this particular indictment. So what we have here, Your Honor, is a separate alleged crime here of a police chase, that the vehicle was I think it was a burgundy Nissan vehicle. It was fully dark tinted.
Appreciate you, John, forever.
So
Appreciate you.
no one could see inside the vehicle from the windows to the vehicle because it was fully tinted. So when you look at what we have here, we're having a separate incident that is over a year after the October 1, 2020 alleged armed robbery. And just to give the court some context on October 1, 2020 alleged armed robbery. So Mr. Huey was arrested on those charges for the October 1, 2020 incident. When he was arrested, he sat in the Fulton County Jail for a period of time, and we had a preliminary hearing on the case, probably sometime in November or so of 2020, give or take. And that particular armed robbery offense, we were able to get the armed robbery case dismissed at the probable cause hearing for lack of evidence. And then the state, they made a decision to indict the case after there was a dismissal at the preliminary hearing stage. So subsequent to that, a grand jury indicted Mr. Huey on these charges from the October 1, 2020 incident. And when they indicted Mr. Huey, they added charges, and therefore they put forth a grand jury bench warrant. There's no indication that they were able to establish that on November 30th, 2021, when this police chase was involved, that Mr. Huey was somehow running from the police because of he knew that there was a grand jury bench warrant or anything of that nature. In fact, Mr. Huey reported to court before Judge Dunaway on the indicted case and was taken into custody in court.
When
So,
was that?
that would have been in 2000. It was in December of 2021. Okay, so he shows up in the court and he has been in custody ever since. So as it relates to this Intrinsic Act, it just doesn't meet the criteria. Then the last step, Your Honor, I'd like to direct the court to Hines versus State. That's going to be 353 Georgia App 710. It's a 2020 case. So after the court does its analysis in terms of whether or not it is an intrinsic act that needs to be part of this case, the court then has to go to the next step of whether or not it survives a 403 analysis. In the Murphy court, the court stated that Murphy has not shown that this alleged deficiency prejudiced him, and that is his lawyer not objecting to certain evidence that was intrinsic coming in. So the Murphy court said, hey, listen, you have to show that you were prejudiced
Well,
by this coming
that
in.
was an effective assistance claim. That's
Sure.
a different kind of procedural stance than what you're talking about.
Agreed, but I agree. What I'm asking the court to look at is if this court says, hey, look, I think that it is intrinsic. I do
Mhm.
think that it somehow meets one of those thresholds.
Right.
Then the court will go to the next step of whether or not there should be a 403 analysis
Sure.
to determine whether it comes in. So with that being said, in Hines versus the State that I previously cited,
Mhm.
there was an intrinsic act, and the intrinsic act was some information that came into to that trial concerning that particular defendant. And in that reference, it stated that this particular defendant, there was a word that was used that she maltreated or injured or harmed her children. And the court believed that that was prejudicial. In this instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in? If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio. They're sending out this information. These are the things that are quoted. He has a history of running, and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into evidence if this court allows this particular intrinsic conduct. And that would prejudice Mr. Huey immensely here, because these are things that are going to go to his character. It's going to go to propensity, and it's going to suggest that there's some type of consciousness of guilt.
Let me ask you this.
Sure.
Is it possible that if I determine that this is intrinsic, that video could be played without the audio?
I imagine they could potentially play it without the audio, but there, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those three items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by a preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the intrinsic acts threshold. And then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November of 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Good afternoon, Your Honor.
Hello.
The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigative Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle. So they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over. But
Was he driving? I mean, did they
He
see
was
him get
driving.
into the driver's seat?
he was driving. He was the only person in the vehicle.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off. and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport. And
Mhm.
so they could not go any further. So they had to pull back and could not keep eyes on him. So that is why the chase was.
Okay, well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two, it appears, and I'm looking at text messages from his phone, and I don't know, all I can do is quote what I have, and these are text messages from November 8th of 2021. He says, just wait till after Christmas and the new year and turn yourself in, see what they talking about.
All right, what? Okay, so, and the chase is November 30th. So this is several weeks before then.
Correct.
Okay.
And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving. And I want to make sure. Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the new year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. And then his response is, I can't miss another Christmas, man. And then he goes in, yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, they might lock you up. He's like, yeah, but then they might not. So it appears from text messages, he was aware that the grand jury at least had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case because those text messages are from.
That doesn't prove that.
November 8th
That doesn't prove that.
of 2021. So
I promise you, Hilton and Love are gossip girls with a
Well,
law
I
degree.
mean, given that he says, yeah, they might lock me up, maybe they won't. I don't think that, I mean, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but it's my ruling, so.
So sit down.
Thank you.
All right.
Oh, burn. Everybody put burn in the chat. Burn. Hilton and Love are gossip girls with a degree. I'm telling you, they gossip girls with a degree. Everything about their case is hearsay.
All right.
Everything
With
about this
regard
case
to
is
the
assumption.
two kind of post-indictment intrinsic acts or arguably intrinsic acts, the stabbing in the jail and the exchange of the Percocet. I've watched the video now about the Percocet. I mean, I think that the state's rendition of what occurred is, pretty much on point. I can't hear what any deputy says, but, I don't think that there was anything particularly off about how they described what happened. I mean, I see what happens on the video. I've looked at some further case law, and how soon do y'all need to know what my ruling is on that? Because I'm kind of having the same thoughts about if we're talking about you know, whether these actually meet in any of the 3 requirements for intrinsic evidence. And then on top of that, 403, I'm just not real certain that these need to come in. I haven't made my final ruling yet, but you know, I don't think that either of these is something that the state can't try the case without, which is not the only test, but I don't think they meet that test. So just kind of FYI on that. I'm having some.
May we offer some case law for the court?
Sure.
We'd offer
Where the microphone at?
an 11th Circuit case decided June 20th, 2024, United States versus Harding, Harding. The site being 2024 US app, Lexus 14995.
Okay, and what does it say?
Your Honor.
Or if you've got a copy of it, that's fine too, or I can just plug it in here.
And Harding, we do have a copy of it.
Okay.
And it's just standing for the proposition generally that an act that occurs after the indictment can be included.
Yeah, okay. No, I've found my own cases that say that. Yeah, that's clear. It's not, post indictment does not bar it from being an intrinsic act. That law is pretty clear.
Right, Judge, and if I may, just very briefly, let me stand up.
That's all right. I mean, I
Voice is
got
just
it.
floating.
It's just,
I guess going back to the court's question in regards to how soon we need an answer from you in regards to that. I can't speak for the state. I'm not sure when they planned to try and present that evidence, but I would ask the court to continue giving it its full analysis, and especially in regards to the 403 and the overarching consideration as to whether or not they really need this particular piece of evidence to make out their case in chief. I don't believe that's the case, but I know that the court is wrestling with that. And I'll look at I don't know if I really need to look at the Harding case because we've already kind of established that that issue is not really an issue.
right.
But I'll be happy to look for some additional case law. and
Okay,
send it to
thank
the
you.
court.
Appreciate it.
Your Honor, you had
Yes.
asked the
Who's
same,
talking
I'm
now?
sorry. Your Honor, you had asked the same of me. I have been pulling some case law, trying to put it together in a coherent presentation instead of just a list for Your Honor.
Okay, sure.
I definitely do want to take a look at this Harding case where it was found that the district court abused its discretion by admitting evidence as being intrinsic. So I certainly would like to take a look at that.
Okay.
So Your Honor, in terms of other cases that talk about intrinsic evidence, we would just cite the court to Jennings versus the state, 318 Georgia, 579. And I am just giving a list right now that for the court's consideration. This is not something that we have to decide right now. This particular one is not coming up at all soon. The next case is Anderson versus the state, which is 313 Georgia, 178.
And what are these standing for?
These are all regarding the intrinsic evidence and how it is that one is, how one is to look at and determine whether evidence is intrinsic, broadly speaking.
Okay. Yeah, actually, US v. Harding, I'm pulling up what I put in my Lexis research folder this morning, and that's actually one of the cases that I was looking at this morning.
Okay. And the last one is Hughes versus the state, 312 Georgia, 149. And we too will present to the court a more coherent sort of overall arching.
All right, appreciate it.
argument.
Okay. All right, so where do we want to turn now? What are y'all ready to talk about?
So Judge, the court likes, we have reviewed we haven't discussed it with Mr. Williams' counsel, but we've reviewed and looked over the Brutin motion redactions. So I'll let counsel for defendant Williams speak to them, because this is Mr. Kendrick's statement that is already in. There are portions that he is arguing are inadmissible because of Brutin. Our position overall is that Brutin specifically requires that that a defendant be directly inculpated. And at these various points, I'll let them explain why they feel like someone is directly inculpated so that I can respond, but we've reviewed them and whenever the courts.
All right, so is it the state's position then that none of the identified portions of Mr. Kendrick's statement actually qualify under Brutin?
No, there's one enumerated time
Okay.
area
Which one is that?
where, and they have it enumerated as,
And has anybody sent me that statement? I think I asked, but I'm not sure that I received it.
Mr. Kendrick's statement. The
Yeah,
court didn't
that's
receive?
the one at issue right now. Yes. And maybe you did. Obviously,
make
I'm
sure.
getting lots of emails through Ms. Percival from all of y'all, but I don't recall seeing it.
I'll make sure.
Maybe somebody could just send it now, since that's what we'll be discussing. All right, so which is the one that you don't have an issue with?
It's the point at which the detectives ask Mr. Kendrick, who do you think did it? And
Okay,
Mr.
so he's actually broken them down into little Roman numerals. So which Roman numeral are we talking about?
I wrote at the bottom my own timestamp. It's at 10004. So that would be. Here it is. It's their number 8. Well, they're number 9 really, but they're number 8 specifically.
Detective Gaither mentions Mr. Stillwell, the one that is labeled that.
Right.
Okay.
Well, it's labeled, I'm sorry, Mr. Kendrick mentions
Okay.
Mr. Stillwell telling detectives who they say
All right,
killed.
that's 8. But, okay, and you agree that that should be excised?
Partially, because what happens is that this is the part that we would ask, that we specifically would argue is not inculpating anyone.
Okay.
What Mr. Kendrick says is they say our crew.
Uh-huh.
And he's, in saying our crew, he's acknowledging that there is a crew. He said, because we're the ones beefing. And then they specifically say, who within your crew?
Uh-huh.
And at some point, Mr. Kendrick says, they say Shannon. That part we would agree comes out, but they didn't enumerate it exactly that way on this
Okay.
sheet of paper. So they say Shannon, we would agree comes out. He then says, they also say Woody, and then they say Shannon and Woody. So the part where he's naming people that they say did it beyond our crew, or people that Mr.
Uh-huh.
Kendrick identifies as his crew, or, you know, in acknowledging that there's a crew, we would argue that part, we would agree, concede
Okay.
that part definitely
All
comes
right.
out.
Okay, so you're saying that they say our crew isn't Brutin, but when it goes further to say, they say, whoever the they is, but they say Shannon, they say Woody, that part you agree?
Yes,
Can
I
be
would say
redacted.
that specifically
Okay.
Shannon comes
Shannon.
out.
they
Yes.
s- Okay. All right, and every other one we're gonna need to look at.
And yes, I believe we should look
Okay.
at the rest of them.
And has anybody come up with any case law about kind of the interplay between Brutin and a RICO? or gang kind of charge? Okay. Okay, that's fine, as long as you're getting me something. They're two separate, well, not entirely separate, but I think we can do this without knowing the answer to that. Uh-huh.
If the state, if I heard correctly, if the state is not, over objection, by the way, intending to play the actual recording, then it's just question and answer. So I assume they're going to advise the witness, whomever the witness is, don't mention Mr. Williams, or if you're going to mention Mr. Williams, what are the specifics? Because otherwise we're just going through something that they may not answer the question.
Your Honor, if I may respond to that, I'm glad Mr. Steele brought that up, because as we were going through these last night, there are portions that I needed to bring to the court's attention that I need the jury to hear Mr. Kendrick say. So we don't intend to play the video.
In
by-
toto.
Right.
Okay.
But there are portions that we would be introducing to have so that the jury hears him. And
Okay.
generally speaking, the overall method of introducing the majority of his statements would be through questions to avoid any implication of
Okay.
Brutin.
All right, well, if there are particular portions that you know you intend to actually have the jury watch and listen to, if you can let the defense know which those are, that'll probably be helpful.
Okay.
Yeah, sure. So just let them know which of the portions, but okay, let's go through all of these if we need to, which it sounds like we need to.
Did you finish it?
So do you want me to be, is there a transcript for this statement, or do I need to be listening to the audio?
We don't have a transcript of this statement.
Okay.
But we can. I don't know how they want to do this. Since the defense has timestamps on it that are different than what we have, I think they may have downloaded it into an MP4 format, so it may be easier for them to play it from their format, because I have a specific time and they.
Sure. Mr. Steele, would you be able to play the video or the portions of the video that you want to litigate for us here so that I can know exactly what that says? Okay, that'd be great. Okay,
Yeah.
sure.
Can I just bring up another concern on
Uh-huh.
this subject? The concerns aren't limited to Brutin. I still like, we're talking about playing a tape where Mr. Kendrick says that other people are saying, he's not saying anything that he knows, he's not telling on anyone, but he's saying other people are saying
Yeah,
that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even.
yeah, no, I agree. That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So.
This whole case is
I
here
get
saying,
Mr.
Judge, what you
Phillips
think is
gonna say we're
not a
intending
shock?
to elicit that.
Exactly.
Been
Judge.
hearsay from the
point is
beginning.
not- And we can tailor the questioning and the presentation of evidence to, not include.
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is Brutin is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
So to speak to that example, for instance, I might ask the detective a question that, did you talked to Mr. Kendrick about the Donovan Thomas murder.
Okay, that answer would be yes.
Yes. Did generally speaking,
Look at Doug.
Let me ask you this.
Uh,
Do you
uh,
think
uh,
that it's
BD.
relevant for the jury to hear that, Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, the people on the street think X, Y, Z is relevant. The relevant part is his acknowledgement that
Our crew.
our
That
crew was
it's an-
beefing with them. There
Okay.
was a us and a them that was in conflict.
Okay, so then the only part of that then that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Okay,
Thank you for actually.
all right,
making that.
so when
This
we're
is the
going
chief
through any of
deputy
these
district
other
attorney,
ones,
y'all.
If there's something similar, just kind of let us know that, okay?
This is the chief deputy district attorney that did not know how to articulate her own
Judge, we
point
just
and
now sent
accusation.
to the court. We're sending to the court the October 6, 2015 interview. Does the court need the evidence reviewer player sent to it again?
So, no, I don't think so, but if we're gonna go by Mr. Steele's playing of it that has his timestamps, I guess I'll just watch that on Zoom. Are we close, Mr. Steele? Okay. Okay.
And I don't want to belabor unnecessary points.
Mhm.
We are looking at it, and I was looking at this for the purpose of Brutin.
Right. Sure.
Unbelievable. Felicia Fee says the judge keeps helping them though. Exactly. Like the judge is helping her to articulate her own point. That's not what a judge is supposed to do. A judge is supposed to listen to the point that they create on their own. It's not my job to proofread and edit and to try to figure out what you're saying to me if you're not saying anything. It was a long pause of nothing. And then she just started talking for Miss Love. Like, that's not how you're supposed to judge or rule over a case. You know what I'm saying? Not in this instance. Not in this instance at all. Now, she has not done any of that with the defense. Because you know why? Because the defense know how to articulate themselves. They're actually good lawyers. Okay. They're actually good lawyers. And speaking of good lawyers, we're gonna highlight Brian Steele today because he was before the Supreme Court of Georgia in a separate case, the State versus Riley.
Any
And
other
we-
little discrete items we can deal with while we're waiting? Nope.
Please hit the like button as you come on in. It is free 99, and you can hit that like button as much as you want. We appreciate it. And thank you all so much for helping me to reach over 1,000 subscribers. I appreciate it. I appreciate it so much. Thank you all so much. I'm very humbled and blessed that you all are even rocking with your boy like that. So thank you so much once again. I appreciate it. Shout out to Kat Knight Williams too as well, man. She surprised me yesterday. She definitely surprised me yesterday in the chat. So thank you so much. I was speechless yesterday. I couldn't believe it. So thank you so much once again. Thank you, Felicia. Thank you. I appreciate it. Thank you. Thank you. Thank you. Over 1,000 subs, y'all. Let's go. Let's go. Let's keep at it. Let's keep going. Let's keep going.
I mean, we're certainly gonna have to do that. I guess we can get started on that. Unless we're really close. 1 minute
you,
away.
Abundance.
All
Thank
right,
you.
we'll just hold for a minute.
Thank you, Abundance. I appreciate it.
Or so, or so.
Thank you, Too True. I
Come on,
appreciate
Mr.
it. Thank
Kokomo.
you.
No pressure. Mr. Steele, how'd your oral?
Oh, you ain't gotta
argument go?
apologize. You good. You good.
The argument was good, but no one remembers the argument, so we'll see what the opinion is.
Okay. Yeah, sure. I mean, we might as well fill our time some way.
So it's in this courthouse. It says indictment on the cover. Second page has, typical indictment things, waives formal reading, etc. Third page has the grand jurors in Fulton County names. Then count 1 through count 6. Former district attorney Paul Howard does hereby charge the appellee with murder. Goes like that. So I didn't try the case. I did the appeal. The Honorable Judge Newkirk granted the motion for new trial, finding no jurisdiction because it was an
Thank you,
accusation.
DPO.
So the Supreme Court was very lively. I mean,
Interesting.
it was an interesting case. And then it got so narrow. I was being asked, well, this is a novel issue. How would a lawyer know? You're saying it's deficient performance. How would a lawyer know? Yeah, I'm like, well, if I know, then anybody could know because I'm not that deep. So
Yeah.
that's what I said. But it was fascinating. It was intellectually stimulating.
Interesting.
And thank you for letting me attend.
Absolutely. Okay. Uh-oh. We spent all that time on the wrong interview. All right, well, maybe we can turn to the PowerPoint issue and at least start making our way through that unless, are we ready now on the right one? Okay.
PowerPoint issue. Let's go.
So we want October 6th, is that right? Okay.
That's the motion that Brian Steele had about the PowerPoint that we went over. I think last week, I think we went over it. So they're going to go ahead and break that down as well. I'm not sure if we are, but I do know that Max Shart has a bond hearing on Zoom that he has to walk away from in a minute. So we may see some hit and miss when it comes to the evidentiary statements and all that kind of stuff. But as of right now, I think Mr. Kokomo is doing his thing. I'm not entirely sure yet. If somebody can fact check me in the chat and let Alicia know. But I believe they are trying to get it together now. The defense is. Yeah, Glanville did say and mention that he was not going to let the PowerPoint come in, and then Miss Love is trying to make it come in. Miss Love is trying to come in
Lawyers
for
and
this
tech.
judge,
I just don't
and then Brian
mix.
Steele is going against that.
I
I'll be
hate
right
to
back, guys.
defend Mr. Kokomo here, but this is a lawyer issue, not a AV issue at this point.
Okay. So, Ms. Love, I know you said the state's timestamps were somewhat off, but can you get close? Maybe that's, maybe we just go that way, since this seems to be taking longer than we had anticipated.
They still waiting on the lawyers to figure this out. Go ahead, look to the chat real quick. Appreciate you, D Pill. She said to support the channel, we'll hit the Cash App or the PayPal. Super thanks or super chat. Appreciate it. For promoting, I appreciate it so much. Says, shaking my head, I thought she said she wasn't going back on other rulings. Yeah, I'm not sure, man. I think I don't know. This judge here is, to me, I think that she believes that this is like a
The defense thinks
playground
they've got it,
type of
and the
situation.
state thinks they've got it. So
Like
the
going back
defense
and
has
forth
got
when
it.
you're
All right,
ruling and
let's do
stuff.
it.
Like whatever Glanville ruled on, I would just leave it
Yes.
at that.
Just to avoid
I wouldn't go back and renege on that. You know what I'm saying?
confusion.
So
The
that's
numbers,
just me.
the times that we are giving is based on the MP4 that was made from the evidence reviewer. So, and we can figure out how to convert that. But the 50 minutes, for instance, is not going to be 50 minutes on evidence reviewer. Correct?
Okay. All right. Well, thankfully, we've got the kind of general subject matter listed as well, so that'll help us.
Somehow we can put on thumb drive.
What we're playing now?
Yeah, but in case God forbid there's an appeal, do you want just to know what we were looking at since we're saying 50 and we could do that?
Sure. Yeah, that's probably the easiest way to do it.
Shout out to
So I
Abundance. She said,
guess
like,
this
share, and
is
subscribe.
the
We're
hearing
small,
on
growing, and loving family. That's
Mr.
right.
Williams'
That is
Brutin
right.
motion. Yeah. Yes. So this will just be Defense Exhibit 1 to the Williams Brutin motion concerning Mr. Kendrick's statements. Thank you.
Like, I think like of other people you associate with, probably anybody particular you can think of. Oh, man, of course, that ain't no question. Like, that ain't like that's not some whole other shit. Like, that's like my rep pump. Like, we do shows, he help me out. He said like he bring me on to his show, just help me, just stay above. So,
Hmm. Now, somebody correct me if I'm wrong. This is Zachary, right? Because they're doing this because he's sick or something like that, right? Is this what we're doing this for? Somebody fact check me, please. I do not want to give out the wrong information. I'm just trying to figure it out myself who that is.
And it should be Detective Gaither saying,
me just a little bit more general idea of what they're talking about at this point in time.
Right. We all need to know that.
Yeah. Yeah.
Okay, Mr. Kendrick.
Regarding the issue where Mr. Kendrick was tased, he was actually chased by police and tased. And Mr. Kendrick then mentioned Duke or Mr. Arnold about the involvement in that, and challenged that. I think that's a Brutin issue. And then Detective Gaither talked about Duke, and then going right into whether Thug is a reason that people went after them, meaning that there was this.
Why, whatever that incident was,
Yes.
occurred, okay.
So, to me, and I'm doing, I think, what the court wants, but this will never come up on a question answer, because no one's going to say to Detective Gaither, I would hope, did you ask about Jeffrey Williams to Mr. Kendrick? It wouldn't happen like that, but that's the first one.
Okay, well then, maybe we can nip that one in the bud.
So there's, if Mr. Steele would not mind just letting that part play from 49
Okay.
so that we could.
Throw them on the bus, but them is 40 over here. When I got tased on Bankhead, they was here. When I got on Collins Boulevard, that was man. I was leaving my little boy from there going, so I had that. He was in the car. It's like, man, y'all see how this shit going on. You got it to me. I try to keep one then with that one, cause it like this shit go down anytime. Like, man, he can have he been on some hang, jealous. So why they coming at? I ain't talking about Duke. I ain't talking about what folks you roll. Why they coming at you? They thinking like I'm bad at it. They think I think I'm bad. Cause I used to carry myself. Like I didn't see of other people you associate with. Probably. Anybody particular you can think of? Oh, of course, that ain't no question, but that ain't like that's on some whole lot of shit. Like that's like my rep pump. We do shows, he help me out. He said like he bring me on to his show, just help me just sell both. So I don't know why Coin, would you feel like I took your spot? A lot of people feel like a lot of people feel like I took their spot. You know what I'm saying? But it's not. I don't get around on niggas try to take on niggas. I'm a brother, man. I got whatever I got going on. We was just spot. We grown, bro. Got spot. We grown ass men. Who the hell are you, man? But then somebody had to tell me like, bro, you know these folks right? Like you take their spot. Right. I had to think about it, look at it from other people's perspective. Okay, that may be what it is. Yeah, but everybody.
Okay, so Your Honor, there's no part that I hear Mr. Williams' name mentioned in there. I didn't hear Thug or Mr. Williams' name mentioned, so I don't.
Okay, well, let's just ask it this way. Do you have any intention of who's this coming in through?
There would be either Detective Thorpe, probably Detective Thorpe later on.
Is he even in this interview?
He's right there in front of you.
The bald head
To the
gentleman.
left.
Oh, okay. I thought you had said Dennis and Gaither. but-
Dennis and Gaither are sitting in front of Mr. Kendrick. And Detective Thorpe is to
Is
his
also
right.
in there.
He
Okay,
is.
all right.
There are three.
So, I mean, you're not going to ask Detective Thorpe if Gaither asked if Williams was a reason why.
No.
Okay, so
absolutely
that
not.
would be one then. This example would be one where you could say, we don't intend to ask that anyway.
Okay, so we do not intend to elicit or ask whether Defendant Williams was
All right, well, let's
whatever. his name is.
circumvent spending the 5 minutes listening to it if you know you're not going to use it anyway, okay? That would be super helpful. Okay, next.
But so when, again, this is one of those them, us, we, them situations. It is simply not one of those situations where we would be saying, you know, are they coming after y'all?
Look at
because
Hilton,
of
dog.
Thug? Are they coming after you because of we wouldn't be eliciting anything about another defendant. But if Mr. Kendrick is talking about a us and a them, like he is in this circumstance, they want to take my spot, things like that, then we would be putting that in. The reason I was saying we're looking at it in terms of Brutin is because if he's not talking about a defendant and he's not saying that person's name and inculpating him, then it's something that we will likely use. If there's a point at which I know that I'm just not going to even touch it, I'll do as the court has instructed, though. If, you know, and say, no, I wasn't even going to ask that anyway. It doesn't do us any good.
Okay, so then what I hear you saying is that while you're not going to elicit that somebody asked if Mr. Williams or Thug might be a reason people are after them, you would maybe ask about some part of Mr. Kendrick's answer there, which said something about they, whoever they is, wanting to take my spot.
Yes.
Okay,
And that we contend is not Brutin.
that would not be Brutin. Okay. Next.
5239, and it should be Detective Dennis speaking. And he talks about Mr. Shannon Stillwell. He calls him Shannon.
Okay, and then you know, you wouldn't be able to mention Mr. Stillwell. Is there some part of this little
So
bit? Go,
I'm sorry.
go ahead.
So he does not say that Mr. Stillwell bought the gun. He does not say anything that directly inculpates Mr. Stillwell. And my understanding is that Brutin does not prohibit the mentioning of.
All right, let me just hear it. I see this is the way it's going to go.
Playing from 5214.
And this is before buying the gun for what? What are we talking about here?
Oh, I'm sorry.
Anybody?
So one of he was stopped with a gun in October and one on January 28th. And they're talking about the guns that he had in those situations. January 28th and October of 2015.
All right, and these are overt acts, or are they?
Yes. One is an intrinsic, January 28th.
Okay. All right, go ahead.
Why not just bring it? True. But I be like, the first man like, fuck these big ass guns. But the second man like, I got to ride with something that's gonna protect myself. I'm like, right. How long they do that? Like, a couple days. Did you buy it after you spoke with Shannon? I bought like before all this stuff happened.
I don't think you, that's, you can stop it. That seems pretty inculpatory of another defendant. Did you buy it after you talked to this person? As if, no. Don't.
Leave that part out.
That
Got
one's
it.
out. Okay. Next.
It's right after that, but it's the same thing, Your Honor. Now it's Mr. Kendrick speaking about Mr. Stillwell. He includes Mr. Arnold as well to clarify what Detective Dennis just said about the gun. And that's at 5251.
Just to go back just a bit, he wasn't saying that Shannon told him to buy the gun. He was orienting Mr. Kendrick as to a conversation with Shannon. It wasn't saying that Shannon tell you to buy the gun. So it wasn't inculpating Shannon. I think that it may be helpful to hear before the part that they started on. It's like, did you talk to Miss Hilton? Yes. Did you buy the gun after you talked to Miss Hilton? Yes. But it has nothing to do with Miss Hilton told me to buy the gun.
Well, I mean, unless you can make it really clear that all that's doing is orienting him in time to something, but to have the question be in front of the jury that is, okay, you had this gun that you got in trouble for. Did you buy it after you talked to one of your co-defendants?
Okay.
Just seems too Brutin-ish to me to permit. And the state ought to want to try a clean case.
do.
So
That's fine.
That-
We don't
that
have to
would not
keep
be
that
clean.
in. Okay.
go ahead. Next one.
This is 5250. You should back it up. This should be Mr. Kendrick. Mr. Kendrick bringing up Mr. Stillwell and Mr. Arnold about clarifying the answer that you were just discussing, although I think that's out, actually. So it's really 54 minutes we can go to, and that should be Mr. Kendrick. And he mentions Mr. Copeland, Duke, or Mr. Arnold, and Rich Homie Kwan, Mr. Lamar, and Mr. Stillwell. And he doesn't want to be associated with them. So we ask that Mr. Stillwell's name be redacted.
All right, well, I'll listen to it. Okay, give me enough so that I can hear the context of why he said it.
See, that's why I be a man today. That's why I fuck up it. I be on more of a defense. It's like, if I wouldn't got that call, I would stay asleep. Right. It show you that though, like I'm so much of a good partner and friend, that way it hurt me. You know what I'm saying? Yeah. Well, I mean shit, this like it. And he get to go with it, like he get out before me and all that and this shit. Yeah. So it's like, God damn, bro. Like it made me look at my loyalty and my friendship like you can't be bending your backward for a lot of these things. And that's why I feel back from the people we all just saying. Right. Which was my original crew member, like the people I was rocking with. That's why I feel back. So it's like I ain't get 100% from none of them. So it's like y'all ain't gonna be getting my 100%.
Who are you speaking of when you said that?
From Shannon Wood, whoever. Dude, it's just everybody here. Going, like everybody, cause all of us have been together at once. Like all of us in rock, joke on all of us. So it's like once I figured out, and then like I don't want no part of it. You feel like, so it's like, what are you gonna?
All right, I mean, he says something about being regular crew members and not getting 100% from them and then saying them by name. I think that's a Brutin issue. So, would you understand if you do intend to ask about this?
Not having mentioned Shannon's name.
Correct. Okay. All right.
Your honors, should be around 58:10, and of course, they'll announce the time to orient, but this is now Detective Dennis's voice, who's mentioned Mr. Stillwell swung first outside a club Crucial. That's the fight that you've been hearing about on the 6th day of January, 2015.
Well, I might not even need to hear that one.
Your Honor, just before we go to that one, I just want to make clear, Mr. Stillwell's name is the only one that is on trial that Mr. Kendrick mentions at the last little clip. Mr. Copeland, Mr. Arnold, Mr. Lamar, they have those names listed in their motion. I'm sure they don't intend that. That is a Brutin violation. They're not on trial. So we would believe that it's okay to mention those names. But
Does the defense want to be heard at all on that, or what your position is on that?
I'm still researching, Your Honor. Like
How did y'all redact this indictment? In
We've
what
been
way?
asking for that to
You
be
say
redacted. It's
redact.
been denied.
Well, what got read to the jury at the beginning?
Everything except, I think, overt act 26 maybe was redacted, maybe 2 overt acts, but I have to check my notes on which ones. Otherwise, the entirety of the indictment was read to the jury.
Including the names of all of the co-defendants that are not on trial?
Yes, every one of them.
Your Honor, at the time, they were on trial. So severance happened during the course. So when we first had the indictment read, it was more than just the 6 that are
Was it
present in the
all,
court.
whatever, 19 of them?
With the exception of maybe,
Yeah.
the ones that hadn't yet been apprehended.
Yeah, so everyone was here except for,
And everybody at that point in time was on trial together?
yeah,
Okay. I mean, it's been a long time.
except for the ones that pled and a few that were not apprehended, yes.
The ones that had not had attorney.
Huh.
Some that had not been apprehended. So there were, I
So,
think, 6 that weren't.
so Mr. Kitchens is indicted. He pled guilty around Thanksgiving of 2023. The jury first came upon us January 4th, 2023. So I made a mistake. Mr. Kitchens pled guilty under Alford in November of 2022. Mr. Arnold did the same. Mr. Sumlin did the same. Mr. Stevens did the same. Mr. Murphy did the same. Mr. Sledge did the same. Thank you. And I should look at the indictment for more. Mr. Garlington never had a lawyer, so he was already removed. Mr. Wani Lee pled guilty around the same
Who
time.
was that last one?
Mr. Wani Lee, L-E-E,
Oh, okay.
and Wani is W-U-N-N-I-E.
Yeah.
So, the state, I'm sure it was a miscalculation, but these people were all included in everything in the indictment, but were not on trial before the veneer panel was first put upon us.
Mm.
And if I leave
Wow.
somebody out, Mr. Eppinger was with us for jury selection. Then he got, something happened and he got removed after that. So he was in a different category. Mr. Blaylock pled guilty after the veneer panel.
Mr. Blaylock has not pled guilty. Mr. Blaylock was severed as well. So I believe I said everyone who had not pled and not been arrested was present. So there were individuals who were severed subsequently. So Mr. Blaylock was severed after the jury was impaneled.
That's true.
Mr. Dorsey was severed. Ms. Eppinger was severed. Mr. Mender was severed after the jury was impaneled.
Right. So the people I mentioned pled before the veneer panel was read the indictment. And I'll look at the indictment. There may be a couple more, but that's my memory. Mr. Winfrey was severed before we did, he was apprehended, I think, afterwards. So name was read to the jury, but he was never with us.
So if they had not pled and they had been arrested, they were all on trial. And so obviously those names were read. Were the names of the people who hadn't been arrested and hadn't pled been read? Were they read? So everybody's name was read. Okay.
Yo, I got my first troll, man. Slimy Miss Love. Let's go. What up, though? Slimy Miss Love. Oh, man. Show Slimy Miss Love some love, man.
I don't know if there were any counts of the was every count of the indictment read?
Oh, I love this chat,
Even if it
dog.
was only against somebody who had already pled?
Yes, sure. Because I think it was pre-recorded, and so everything was read. To answer your question, yes.
Okay. there any objection to that? Okay.
When the court says objection to that and there's a yes, we get clarity, because on the yes.
I mean, honestly, at this point, that'll be a motion for new trial issue if it gets to that stage. I'm just trying to figure out what this jury has heard. Y'all would not intend to send out an unredacted indictment if we get to deliberation, right?
We had actually talked about redacting the indictment. I think we were
Okay,
actually,
all right, well, good. Because I don't think an unredacted one should go out. All right, anyway, back to what we were doing, so I mean, the question was with regard to people who are not on trial here now with these 6, is there any kind of objection to those people being mentioned?
Yes, so I'm finding Brutin under conspiracy
Yeah,
and directly impact, and that's what I have to get to the. court.
okay, all right, well, why don't we circle back on this one then? Because that, obviously what the law is will determine what the answer is.
and
So it's definitely out with regard to naming anybody on trial here other than Mr. Kendrick, but with regard to anybody else,
I heard the same thing.
TBD, depending upon what the law says about that.
yes, Your Honor.
Okay. So y'all get the next one lined up and let me jot myself a note on that.
The state, man, they slick. They read a unredacted indictment to the jury in the beginning of this trial, which is what you're not supposed to do. Then redacted it
I'm
later.
ready for the next one.
It's crazy. Brian still did a great job on his Brutin motion on certain parts that he want to get out. I mean, he's still doing it now. He's doing an excellent job. Everybody put Brian Steele in the chat real quick. He's doing an excellent job with this because the judge so far is excluding these things. So
Detective Gaither is asking, this is at 10055. So then after Woody got jumped, you know who Woody is? Who shot up the studio TIG, Mr. Kendrick.
shout out to
states, "I don't know."
Janiyah May.
Mr. Gaither said,
Appreciate you watching.
I heard your crew shot up TIG after Woody got jumped on. There's a discussion of where is TIG. Then Detective Gaither says Metropolitan, like over there by Thug Studio. Mr. Kendrick asked, where's Thug Studio at? And then they talk about that location. They talk about YF and Lucy. And then at 103, Detective Dennis say, you still on Bloody J when he got locked up, and it goes on to that event. And
So is this just because Mr. Williams' studio is mentioned
Well,
to orient people to where things are?
well, at 102, it's just about the studio, but I was targeting the RICO conspiracy. So I was targeting the, this is where,
Shout out to Jeremy Leggett. Appreciate you watching with us.
actually, I'll withdraw that because
Okay.
it does not mention, I apologize.
All right, no problem.
All right, number 105:19, 1:05:19, Detective Dennis mentions Mr. Williams' quote unquote girl regarding a shooting, supposed shooting of that.
Shout out to Toby
event.
Rasco the third.
And that
Hashtag
is,
Bubba says free thug. I appreciate you rocking with us today.
It's 104:32. Detective Dennis states, didn't you catch them down bad? That's a reference to Mr. Kendrick's music. they like
Casper,
it's a verse in a song.
what up, dope?
And then Detective Dennis says, so who shot up Thugs Girls event? Or did you hear about that? And Mr. Kendrick says, I don't know. That's my first.
Casper's
time
the excellent
hearing
line from Cat Nat Williams channel. Excellent mod.
What's the response?
Doesn't, number one, evidence of that has already come in through Dennis, but number two, that in no way inculpates Mr. Williams in anything because it references
His
him as-
girl being a victim.
right.
Okay, yeah, I mean, I don't think that's a Brutin.
So my issue with that then would fall back on a different issue then. What's the point? The answer is, I don't know anything about it. So we're now
Right.
just using
So
the
now we
question.
have a relevance objection. No, we'll do them all at the same time, so
So,
we don't.
I don't have a problem not having him since he doesn't know anything about it, keeping that part out. He said, I don't know
Okay.
about that. I don't have any problem keeping
All
that
right,
part out.
thank you.
Next is 108, 1:08:40. And this is the part you heard earlier that may be stipulated to. Mr. Kendrick mentions Mr. Stillwell telling detectives who, quote unquote, they.
Right, and on that one, what would be permissible to ask about is that at around this time,
They were beefing. with
our crew were beefing with
them.
the other group, but not anything about the rumors or anything like that. So that one I think is clear. Okay. Next one.
The next, Your Honor, will be it's really the same flow, but it's 108:51, so it's only 11 seconds later. And Mr. Kendrick, mentions Mr. Copeland sharing that he was tied up with Mr. Stillwell and specifically, and then Mr. Kendrick identifies a photograph 8 seconds later of Mr. Stillwell. Then Detective Thorpe mentions Mr. Stillwell and clarifies that the word is that Mr. Stillwell and Mr. Copeland killed Mr. Thomas. And Mr. Kendrick speaks to that.
We
So now-
don't have any intent to bring that out.
Any of that?
Right.
Okay.
That-
Okay, the next is 1:11:30. And it's Detective Gaither mentioning that Mr. Stillwell is the person that whoever everyone is, brings up related to the murder of Mr. Thomas.
And this falls in with what we initially said, that when they were talking about who they said killed Donovan and bringing up Mr. Stillwell's name, we have no intention of doing any of that.
Okay.
Okay. The next one is 1:13:44. And it's Detective Thorpe, I believe.
All right.
And he says, people talk to you in the city, all put you four involved in the murder of some kind. Mr. Kendrick denies it, says they are lying. Detective Gaither says, you think anybody going to tell the same story? Mr. Kendrick asked, what did they tell? Detective Gaither said, I heard you was in the car. Mr. Kendrick said, what car? Detective Gaither said, the Infinity rental from Thug. And then Mr. Kendrick said, no, I wasn't. Check whatever, my phone, whatever you want to check. And then Detective Gaither says, we did. It was said a whole lot. And then they go off on that. So I was objecting to Mr. Williams or Thug being mentioned.
Your Honor, that whole, all of that colloquy is part and parcel of them talking about who people said killed Donovan Thomas. Anytime we're talking about any of these defendants being rumored to have killed Donovan Thomas, the state has no plans to get near that part. Now, Mr. Kendrick denying that he was in a rental by Mr. Williams, we would proffer that type of information because it would not inculpate Mr. Williams.
Yeah, I agree with that. I mean, I think it's already in evidence that Mr. Williams rented an Infinity, right?
Yes.
And up for dispute whether that was involved or not.
Right.
But saying, the Infinity that he rented doesn't inculpate him directly. So that I would be okay with. I mean, I don't think there's a Brutin violation if you ask or get an answer that talks about the Infinity that Mr. Williams rented or that Thug rented. Okay.
The next, and I'm skipping based upon what the state just said about that whole colloquy.
Okay.
So it would go to 1:18:31. And that's after 1:17:35. Mr. Kendrick reaffirms he has nothing to do with the murder of Mr. Thomas. And then at 1:18:25, Detective Gaither asks about NARD, NARD, and DUWOP, DUWOP, where they are now. And Mr. Kendrick explains he's almost questionably locked up. And then the target event, Your Honor, is Detective Gaither asked from January 10th until today, how many times do you think Shannon been locked up? We'd like that redacted.
My apologies for leaving that out. I would not put that in.
Okay.
Okay. The next one,
The part about Mr. Stillwell being locked up, the other
Right.
part, yeah.
Yeah.
the next one is 1:21:25, Your Honor. And at that point, Mr. Kendrick had shared with the detectives that he went to Miami after January 10th. Detective Dennis asked who all went. The answer by Mr. Kendrick is everybody. Detective Gaither said, who is everybody? And then Mr. Kendrick starts naming little d, everybody. And then Detective Dennis points to the photograph of Shannon Stillwell. Mr. Kendrick says, yes. He says, yeah, actually, H.
Okay.
So that's the part that we were taking out, the picture and the pointing.
Well,
This is just him saying, here's who all went to Miami.
Yes,
That
immediately after
doesn't
the killing.
inculpate anybody directly in anything. It might be argued to be a part of the evidence, but that wouldn't be a Brutin violation.
Okay, we're just raising objections then, if that's okay. When I say okay, I'm not waiving anything.
I understand.
Okay, thank you. I said okay, but thank you.
Yeah.
All right, the next one is going to be included. Did Thug went? Was a question by Detective Gaither. The answer is yes or yeah. So I assume it's the same ruling.
Shout out to Flesh of the Gods. Excellent,
Next
excellent
one,
content
Your
creator.
Honor, would
Somebody from
be,
one of my mods, go ahead and put his link in the chat. Excellent content creator, man. Excellent. Thank you so much for stopping by, man. I appreciate it.
Detective Gaither asked Mr. Kendrick, how long did Mr. Williams stay in Miami? So I'm assuming it's the same ruling. So I'm moving on from that one.
Okay. So the one about before that 1.23.06 about Mr. Stillwell getting calls.
Yes, I should have included.
That
I
doesn't-
skipped that one accidentally.
And what'd you say, Ms. Love?
I'll let the court decide on that. I'll let the court hear that because I didn't count that as inculpating because everybody was, what he's contending is that people were calling, but I'll have to hear that part again.
Okay, let's just
because
hear that part because I'm not sure what it says. And
Started about 1:22:40, if you can, Mr.
Okay.
Kokomo. And what it should say is, it should be Detective Dennis
Okay.
asking about what conversation was like on the way down to Miami. Detective Dennis specifically, I believe, said, Your Honor, the ride down had to be some type of, just like you just said, like when Duke got jumped on, people started hitting your line. So you all started to get worried, and Mr. Kendrick said, it wasn't on my conscience. And then in there, they talk about Mr. Stillwell was probably getting calls.
all right, let's just hear.
One of conversation.
Everybody just sitting there like,
Yeah, I was just stoned with it. Like I get my own strong heart. So.
right, what I'm saying is, the ride down had to be some type of,
I don't know. I didn't
because
know
it's
anything.
just like you just said, when Duke got jumped on, people start hitting your line.
Yeah.
What's going down? So y'all had to start getting word that these names are out there as nuts just got killed.
Yeah, but it like they think it was them, but it wasn't on my country or the folk want to call me. Like, yeah, you know what I'm saying? They want.
But if they're your people, it's almost like you guilty by association to an extent where if this happens,
We wouldn't have any problem taking that whole last 2 or 3 sentences out. Like, they were probably getting calls thinking it was them, and then Dennis saying it was your people, you guilty by association. Like that, those 3 or 4 lines, we don't have any problem coming out.
All right, does that cover it?
Yeah, Mr. Kendrick, I'm sure it covers it. Specifically said Shannon, so I'm assuming that's it covered it too.
Let's make sure.
Yes,
Okay.
yes.
Okay,
Excuse me, Your Honor, can we take 5 minutes before we continue down the list?
sure. Yeah, that's fine. Let's take a quick break.
Thank you.
Sure.
All right, they're going to take a quick break real quick. And while they're doing that, I'm going to bring up something from Thugger Daily real quick concerning this particular, what we're looking at right now, basically. Okay. Once again, shout out to Flesh of the Gods, man. Appreciate you coming by, yo. This is like, I got some big dogs in the chat, man. You know what I'm saying? Thank you, Chill, for dropping the link. Go ahead and drop the link to Flesh of the Gods, man. I mean, excellent content creator. I mean, he does excellent work. No, I mean, you won't be disappointed at all. You won't be disappointed. All right. That's for sure. Slimy Miss Love. Appreciate you. Yo, Slimy Miss Love in the building, dog. Slimy Miss Love said, I'm better than Brian Steele. Are you? Okay. All right, we'll see. No, but check this out. So what we basically looking at, right, is the fact that right here it says, this is from Thugger Daily, y'all. And this is from the X.com account. Says here that Yak Gotti in 2015 pled guilty to driving to the territory of a rival gang for retaliation. As part of his plea, he admitted YSL is a gang. The judge agreed the plea cannot be used against anyone except Yak Gotti himself and will give instructions to the jury as so. So basically, again, his testimony cannot be against anyone else. So this is what Brian Steele is doing. He's basically saying, hey, we want to go ahead and exclude anything that Yak Gotti says about Stillwell, Mr. Williams, Huey, anyone, right? That's a part of this trial. And also, Brian Steele is insinuating the fact that anyone that's indicted, anyone that was indicted, period, should not be a part of, it shouldn't be admitted at all, period. So, I mean, that's a good point. Again, it's brutal motion, is brutal violation. Okay, so what brutal motion? When you do something of that nature. So that's basically what his motion was before. What we was kind of touching on a little bit is the fact that, Yak Gotti is mentioning people's names that's involved in this trial, in this case. And so because of that, it was already agreed that anything that he says in his plea cannot be used against anybody that's on trial right now. So Brian Steele is doing an excellent job, man. Brian Steele is doing an excellent job with this right now. So I mean, it's going along pretty well. All right. Let's see here. Thugger Daily has some other stuff here. We're gonna just, matter of fact, peruse. Let's peruse a little bit here. All right. Let's go ahead and blow it up a little bit while they on break. Oh, I want to blow this up, not myself. All right. Yak Gotti. Hold on. It says going over Yak Gotti's police interview outside of the presence of the jury and redacting statements that may be incriminating to other co-defendants. Note that Yak Gotti never cooperated, but the state wants to use his statements as a portion, use his portion of his 2015 interview. So Yak Gotti never cooperated with the state, but the state wants to use his interview as evidence, like they do anything else. Like all they have is the most hearsay stuff possible. You know what I'm saying? Again, I think that Hilton and Love is nothing but gossip girls with a law degree. I mean, for real. Gossip girls with a law degree. They want to do a lot of hearsay, a lot of, yeah, they told me, yeah, I heard, us, we, them. They're not specific about what it is that they are actually implementing as evidence. Casper says Brian Steele just argued this morning to the Supreme Court. Yes, we're going to go over that today too. I'm gonna go over that with my audience today about the problem adding charges after a grand jury, exactly, which indirectly could apply to YSL trial. Absolutely, that's one of the things that Brian Steele mentioned before. He mentioned an emotion, I believe. He was trying to say, hey, you know, you all indicted this incorrectly. Basically, you know, these charges are not warranted. They've been miscategorized. They're not what you say they are. You know what I'm saying? And so because of that, this trial should be released or a mistrial and things of that nature. But again, Schlimeville, you know what I'm saying, Judge Suge Knight Schlimeville said, I'm going to deny that motion. And that's what he did. But he was able to revisit it. This is the State versus Riley. We're actually going to go through that a little bit later after they're done with court. I'm going to also show the video about it as well. Yeah, gossip girls. They are. Hilton and Love is gossip girls. Great point, by the way, Casper. I appreciate that. Yeah, gossip girls for sure. You know what I'm saying? With a degree in law. That's basically what they are. You know, if their idea of evidence is, oh, you heard something? Okay. Tell me what you heard. You know what I'm saying? Tell me what you heard. And then we'll go ahead and set something up. We'll make it look like evidence, you know, when it's actually none there. You feel me? So that is the best I could say about it. Abundance says, Tay, did you watch the Professor Nez video I sent you? Yes, I didn't finish it, but I'm going to finish the rest of it today. But yes, that interview was absolutely great. Okay, but as a matter of fact, you know what? I'm glad you said something about that because we can actually take a look at a portion of it on X. All right, because again, X, I think Professor Nez put a clip of it up. Go ahead and see. Now I could probably show it from the X account. Okay, I could definitely do that. But I can't show it from his YouTube account. Let me see if he has it here. I'm looking for it right now, guys. Give me 1 second here. Oh, maybe I can. Let me go through my bookmarks because I did bookmark some stuff. Yes. Okay, here we go. Good, great. Oh man, thank God for bookmarks. You feel me? So this is actually from an account, person named L, and they got a clip of it. It's like 2 minutes and some change. Let's go ahead and look at it real quick, okay? This is Ashley Merchant and Professor Nez interview, and they're talking about the perspective pretty much on this case. And she did mention how Paul Howard had this case and did not want to pursue the case because of the fact that they didn't trust Woody and it was a lack of evidence and a whole bunch of other stuff. So let's listen to this real quick.
Why do you think she denied the motions for mistrial? To me, it seems obvious.
Because of the speedy trial demand. I'm convinced that the reason she did, so
unpack that. Speedy
yeah,
trial
so Jeffrey Williams, who is Brian Steele's client,
AKA Young Thug.
Right. They filed a speedy trial demand. So that's why the case had to go to trial so quickly. So in the state of Georgia, you don't get a speedy trial unless you actually ask for it. So we have a statute that says you have to demand a speedy trial. If you do that demand, they have to try you within 2 terms of court. Okay. So Fulton County, the terms of court are 2 months. So they had to get the jury impaneled, picked, all of that stuff within 2 terms. That's one of the reasons they were kind of hurrying it up, the jury selection, which, I mean, it doesn't seem like it was hurried up, but they did.
Right.
And we
I
had
know, it doesn't seem like it.
I know. Well, we had some tolling because of COVID. So there was some, we had some of those statutes were sort of stopped because of COVID. So they had some
Oh, right,
leniency with
right.
that. But essentially they needed to have the jury sworn by a certain date. They got that done, but they don't have any time left. So if this trial goes off the tracks and it's a mistrial, they don't have any time left to retry Jeffrey Williams. So if she had granted a mistrial and she had said it was the state's fault to grant the mistrial, he essentially would have never been able to be tried. And I think that probably weighed into her decision because
Whoa. Let's back the truck up, lady. Back the truck up, lady. Let's listen to this again.
Tolling because of COVID. So there was some, we had some of those statutes were sort of stopped because of COVID. So they had some leniency with that. But essentially they needed to have the jury sworn by a certain date. They got that done, but they don't have any time left. So if this trial goes off the tracks and it's a mistrial, they don't have any time left to retry Jeffrey Williams. So if she had granted a mistrial and she had said it was the state's fault to grant the mistrial, he essentially would have never been able to be tried. And I think that probably weighed into her decision because he's the only one that has that speedy trial. The other folks don't. But if she had granted the mistrial, yeah, it would have been really
So Thug is the only one that has the right to a speedy trial. The rest of them doesn't. It sounds like the state is always late. And since we're late, please don't make it a mistrial. We don't have enough time. Hold on. Let's listen to this again, y'all. This is good information. Flesh of God said, yeah, that was a good interview. Georgia has some grimy law. They do. I looked at some of their actual law, like their actual statutes. Man, they have some crazy stuff. Like, I think it was like 2 grams or 4 grams of heroin is considered trafficking or something like that. I'm like, what? What? No actual weight. This is crazy, man. This is crazy. Let's listen to it again. I'm sorry, y'all.
They got that done, but they don't have any time left. So if this trial goes off the tracks and it's a mistrial, they don't have any time left to retry Jeffrey Williams. So if she had granted a mistrial and she had
You know what she's saying about they don't have any time left. I'm assuming she's referring to court time. They don't have enough court time left. It seems. Again, this is taxpayers' money that's paying for this. On top of the fact that Young Thug is also paying his lawyer. You know what I'm saying? Keith Adams and Brian Steele. So excellent point here.
had said it was the state's fault to grant the mistrial, he essentially would have never been able to be tried. And I think that probably weighed into her decision because he's the only one that has that speedy trial. The other folks don't. But if she had granted the mistrial, yeah, it would have been really unlikely that the case could have actually gone through in the time that it needed to go. And that, unfortunately, I think had something to do with it,
It seems thank you so much that's why you're here, Ashley. Thank you so much.
Well, and I can tell you,
that's crazy.
In my experience is judges don't like to decide stuff if they don't have to. And let me just unpack that a little. If a judge thinks that the defense is winning, they're not as likely to grant a directed verdict or a mistrial or something like that, because it's a lot easier if the jury finds them not guilty. There's no appeals. No appeals. If you get a not guilty verdict, no.
Hold up. Wait. This is the bias we're talking about, right? Hold up. She said if the judge feels like the defense is winning, we're not going to do anything, no mistrial, no dismissal. No. We're most likely going to just let it ride. Yikes, dude.
Is winning. They're not as likely to grant a directed verdict or a mistrial or something like that, because it's a lot easier if the jury finds them not guilty. There's no appeals. No appeals. If you get a not guilty verdict, no appeals. And it doesn't fall back on the judge during election cycle, nothing like that. So, I've noticed that a lot of times.
Okay, I see what it is. Okay. So they wanted to go through. If it goes not guilty, there's no appeal for it. Okay,
the jury finds them not guilty. There's no appeals. No appeals. If you get a not guilty verdict, no appeals. And it doesn't fall back on the judge during election cycle, nothing like that. So, I've noticed that a lot of times where they think the defense might be winning, they're not as likely to grant these types.
Is there any Why do you
So the defense is winning, they're not going to grant it because it doesn't have to fall back on them when it comes to appeal time because it's not guilty, so there's no appeal. Interesting, man. See, again, this is all political stuff we're looking at. This is so political, dog. This is so political. This is so political. So now it leads. So now I have a question. I have a question now, and they're still not back yet. I'm gonna keep it up real quick here. Let's see until they come back. I have a question. If you are a judge, let's say for instance you're a judge, right? You're in this same seat, and you know that the state does not have enough evidence to win a trial. You know also that the defense has evidence to win a trial, but you have to play fair, basically, right? Based on what Ashley Merchant just said, if you have political aspirations to be, let's say, the chief judge of a certain superior court, would you allow the state to hang themselves knowing that in your professional opinion, in your professional outlook, that the jury is going to grant this not guilty? You know that it's not going to be an appeal. You know it's not going to fall back on you. Would you allow that to happen? So that way it can help you elevate your political career? Isn't that something you would probably do? Or is that something you wouldn't do? Because according to Ashley, she's like, if I know the defense is winning, I'm gonna let it ride, because if it comes out not guilty, it don't fall back on me. It don't fall back on the judge. There's no appeal for it because it's not guilty. That's interesting, man. Let me know what y'all think about that. Let me know what y'all think about that. If you're the judge, you know the state hanging themselves, are you just gonna let them hang themselves knowing that you're gonna be straight? Or are you gonna try to control the narrative of the trial? Because Glanville definitely tried to control the narrative of the trial for sure. And he was in cahoots with the state. We know that. We know that he was a prosecutor for the state. Absolutely. There's no doubt in our minds. Glanville was slimy as hell. Okay. Real talk. But that's interesting. How would you all handle that? Let me know what y'all think in the chat. How would you handle that? Exactly. Von B said, of course the judge would allow that to happen. It's wiping their hands clean of it. Exactly. So I don't have to get my hands dirty. I don't have to get my hands dirty. So I'm gonna let it ride. And I have aspirations politically as well. Because some people are like, oh, I would do this or I would do that. But when you get the full scope of everything, it's like, you know what? They got the rope. They're hanging themselves. I'm gonna let them do that. I'm gonna let them do that. All right, we back in court.
I believe it's included in your honorable court's ruling. It's approximately 1:2539. Detective Gaither asked Mr. Kendrick how long Mr. Williams was in Miami, and he answers a couple of weeks. So I assume that your court said that that's not inculpatory. So I'm moving on.
All right.
The next one is it's a visual. So if they're
Okay.
not showing the video at this, it won't matter.
All right.
But Detective Dennis points to the photograph of Mr. Stillwell and says he's all about that action. And they're talking about shooting people. They're talking about violence. So you may have to hear that, but and see it, but we would object to that.
You're not going to use that. All right. States agrees. Well, they don't agree it's Brutin, but they're not going to be using it.
Okay. The next one is Detective Thorpe. It's at 1:33:55. Mentions Mr. Williams and how Detective Thorpe heard that people went to Mr. Williams' home after the killing of Donovan Thomas. You may have ruled because of the way you treated the rental car that's not Brutin, but that's what I flagged.
All right. Do you think I need to hear it, or is it pretty much?
That's pretty much it.
Okay. Yep. That would not be Brutin.
The next one is at approximately 1:43:20. And I'm not so sure this is covered by Brutin, but Detective Gaither asked Mr. Stillwell if he drives a Volkswagen, but I flagged it. But if that's not directly inculpatory, I understand that, but that's
Alright.
what is said.
Okay, and this is just, does Mr. Stillwell or his nickname drive a Volkswagen? Yeah.
Yes. The next one is 1:47:18. Detective Gaither asks, what was in its, I say Mr. Williams, but Thug's demeanor when he pulled up to the McDonald's, and Mr. Kendrick says he cannot speak on that, so I assume that that's not under this court's, honorable court's ruling, anything we deal with Brutin, so I'm moving on.
Okay.
And if I'm waiving something,
No,
you
you are,
say
you are
no.
correct
Okay.
in your assumption.
And then the next one is 1:48:07. Detective Gaither asks, so that night, meaning the killing, you didn't meet up with Mr. Williams, and then ask the same for Mr. Stillwell based upon your honorable court's ruling. I believe that when we're going to skip, and if I'm wrong, please tell me I'm wrong, but
Does, what's the state's intention with regard to anything you might ask about that?
Given his alibi, we would, well, I don't know what, we would probably be
Asking that? Okay, well, yeah, I mean, I think that would be okay.
and then the next one is two. Well, it's really the same, Your Honor. It's clarifying the same thing. It didn't meet up with Mr. Williams or Thug and Mr. Stillwell, so
Okay,
that's it.
Yeah,
That would
same.
cover the entirety. Now, that's just for Brutin, but again, I will send to this honorable court, and there are cases on a RICO conspiracy, a conspiracy, and Brutin.
okay. I'll be on the lookout for that and the state's position on that also. All right, so we can circle back to going through the evidence that's going to come in with the next few witnesses, including Mr. Sprinkle. If y'all are ready on that, we can move on to the wiretap evidence that the state intends to use. We can,
the PowerPoint maybe is.
I mean, we can do the PowerPoint. Would the wiretap evidence come before the PowerPoint?
No,
in-
it would come
Okay,
after the
PowerPoint. All right, yeah, we can look at that. So everybody should have the kind of revised PowerPoint, I guess, that the state provided over the weekend, I think.
Easily run through it.
Yeah.
And Your Honor, if I may just turn my back, you will give a thumb drive to Ms. Winfrey. Yes.
And so what the state sent over at this point would be, y'all have taken out everything that you don't intend to use. So the hope is for y'all that all of what you provided is usable, and we'll sort that out. All right. Yeah, so if somebody wouldn't mind, I guess, just giving us kind of a slide by slide. And I don't know that it needs to be displayed on Zoom as long as we're all looking at the same thing. That might be a better approach. So let's all just get our email that sent it over and open it up and look at the slides on our personal computers or laptops.
Sunday at 9:15 p.m. It was sent Sunday at 9:15.
All right. And was it a Dropbox link or was it an attachment?
It was an attachment with a PDF.
Okay, right. Okay. All right, is everybody ready? Everybody got it up? Yes, yes, yes. Okay. All right. Slide 1, I don't see how the state could possibly need that slide.
No, that's not, no, I mean, it's not.
Okay. Slide 1's out. Slide 2, this is just sort of,
These are identifiers that identifiers that APD has identified, and
all right, hadn't there already been testimony about that?
there has been testimony about snakes and tattoos and red flags. Yes,
Okay, so that one's out too.
if you say it is, it is.
Huh?
And
I mean,
just to make sure we're all on the same page, what you're referring to as slide number 2 is the picture that has an arm with a
Yeah.
tattoo. Okay.
Yeah.
Which also coincidentally is the second slide in the attachment. That's what I'm going by.
All right. Just didn't want to make sure you weren't
All
looking
right.
at the
So they're going over the motion
Okay.
about the PowerPoint right now.
All right.
literally.
Okay, good. All right. Slide number 3. What's y'all's argument for needing that?
Okay, we can.
Because we've still got some language on all of this too.
So we can take out, well, we can take out all the language.
Mm-hmm.
We take out all the language.
Okay.
Can you take that aside? John, may we be allowed to remove the Mondo board, the IT department?
Yes, that would be wonderful. We're not going to use it, so out it goes. So
Thank you.
y'all go ahead and, yeah.
Not right now.
Okay. What about these 5 pictures?
So the pictures, Judge, are just, as he's talking, he would.
All right, so who are I see we've got
Defendant Williams.
Mr. Williams, Rich Homie Kwan.
Birmingham.
Are there pictures already in evidence of
Yes.
those 3 people?
Yes.
Then use the pictures already in evidence. How about the bottom 2? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
Yes.
There is a picture of him in evidence.
All right, use that. What's the middle 5th one?
And this is Defendant Williams. And
Sarah,
pre the gang, pre the dispute, the war,
okay. I mean, is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
Hold on one second, Your Honor. We have videos of the groups of
All right, so
persons
you could do a
together.
still from a video.
We
Okay,
can.
all right, how about slide 4?
This is just, Your Honor, and our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for what feels like ever. So they sort of know who he is. They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just put forth that there's,
Is there a picture of Mr. Watts in evidence?
Yes,
but
there
they're
is.
demonstrative.
Look kind of similar to this?
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that would cause either defendant to be in danger of being convicted of something or on something other than proof of the crimes we have listed in the
Are
indictment.
they gonna, for some reason, be talking about Mr. Copeland and Mr. Watts together, that they're like,
Yes.
it's gonna be crucial for the jury to see, here's Copeland and here's Watts?
Not crucial. But he will be talking about a specific interaction, specific.
Okay, well, he can
antagonistic.
talk about that without this, and if you need to like have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence?
The gambling house that.
Do we have pictures already in evidence of that?
No.
Okay, then this one's fine. Slide 6. With the stack of money and obscene gesture.
Hold on. Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watts. So
Okay.
We've also got video of him doing exactly the same thing.
we don't have that video.
Yes, we do. We've had a video and
All
choose
right,
of him.
well, don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June. However, that was after 3 o'clock. And so we did not enter
Ah.
it again
Okay.
this time around. So I do not believe the video is in evidence. I'll double check,
Okay.
but I believe that was after
All
3
right.
o'clock.
Actually, good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay, this one's fine. He can use this one.
Can I inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts,
The flashing of the large sums of money.
not the flipping the bird.
I mean,
Yes.
Oh my
no?
God.
the flipping the bird, I mean, it wouldn't have, our argument is that it's relevant because it shows Mr. Copeland with that huge stack of money. that
Gossip
we're
Girl,
talking
man.
about, And it makes,
Is this the night of,
it's,
or is this just?
you say the night of, not
The
Donovan
night-
Thomas.
No, the night that the beef starts between he and Watts.
No, Your Honor, it is not.
It's just an example of him with a
And the
bunch of
bird
money.
and holding money.
An exemplar. Good
It's-
word.
I think it's January the 8th.
Oh my God, man.
The 6th, January the 6th. So it was the night, it preceded it. That's the night that the fight started that led to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time when Bloody James punched out.
So this is a picture from the night that, it all got shot up or
I'll-
something?
I'll confirm, but that's what
After-
my understanding that is January the 6th.
I don't know January the 6th. What does that mean?
I don't know. I don't know. Maybe they know what he was wearing to the club
The
that night.
detective that gave it to us, so.
My recollection is that he had different clothes on the night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night,
We
that's
will.
fine. Otherwise, it's just an example of, hey,
Well, not just.
here's what we mean about flashing money.
No, the large amounts of money.
Right.
I think during the course of the interviews that the jury has heard, you hear
That
them
doesn't even make
talking about
sense.
a very, very large sum of money.
Right.
And, one might argue or wonder, what kind of money, how much money did he have access to that kind of money? Him having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So,
No.
the relevance bar is, of course, as the court knows, is a low
Yeah.
bar, and
Just
that
exclude
he's
it, Judge.
sitting there with that.
Okay. Well, he also is flashing the bird though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So maybe there's why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? So we'll revisit that when we've got some more info.
Why are we even revisiting something that's so insignificant? Jesus.
All right, slide 7. This just shows a couple of the,
And again, the
events
reason
of
why
what
they
y'all
don't
do
know
the
the date
testimony about
is
the
because they don't
methodology.
have the metadata of the photos.
CIG
You need
Studios that,
metadata.
Mr. Copeland is alleged to have shot up, or the believed to have shot up.
We've had a number of crime scene photos of the Metropolitan. So there are a number of photos of that in already.
So it doesn't, there's nothing, if Detective Dennis is talking about this,
Mhm.
putting it up doesn't take extra time. It just orients the jury as to what he's talking about. So it's a demonstrative aid that orients the jury, that is helpful to the jury, that is substantially similar to what that is exactly what he's talking about. So there's nothing that should preclude
Okay,
him
and
from showing it to the jury.
TIG is who's,
Think It's a Game
Right,
is the company that Rich Homie Quan was under, that Think It's a Game Studios is inside
Right.
that building right
okay.
there.
This one's fine. All right, moving on to slide 8. So this is several pictures of Mr. Thomas. We definitely do not need the Club Crucial, we'll always remember you part of that.
Facts.
And, you know,
Facts. Basically false
the
advertising.
language about whether he's a
Basically
high
false
ranking member
advertising.
of a rival gang, I mean, that's,
It can come out.
thank you.
But yeah.
I know it's asserted that he is, but this sets it forth like
Yes. It can-
fact, and
it-
that's for the jury to determine.
Yes, John. I'm just trying to X over everything.
Okay, so,
Did you have something?
I mean, those 3 pictures basically of Mr. Thomas and some of his
Brothers, family.
Well,
whomever.
I would object to the pictures of,
Agreed.
well, the pictures period. I mean, I don't know what the relevance is and what a jury would need, or how this would aid the jury in understanding any testimony from Detective Dennis to show pictures of him and various individuals just standing around.
So, do you want to elucidate us on that?
Yes, we can take.
Okay. So they won't use that one. All right, slide 9.
This is a waste.
So slide 9 shows just the
Glanville already excluded
typos.
this whole PowerPoint. I don't even know why we're going over it again.
Are these actual posts already in evidence?
No, we did not.
Okay, well, if they're not, then I would think if you throw these up, that is more than demonstrative. So if you want to enter those as examples, we can talk
Okay.
about that, but
Okay.
otherwise he can just testify that
Yes, he
what
did.
happened on social
Yes, he
media
did.
after the death.
Okay.
All right, slide 10. Yeah.
And he ruled it out because Love was trying to
Objecting
submit it
to
late.
Detective Dennis saying this is what I saw on social, okay, you understand that.
Okay.
It would
and
be hearsay.
because- And how would,
So crazy.
well, no, what he saw on social media, he saw on social media.
If he's going to say, I saw on social media and someone posted the following, I'm assuming that's for the truth of the matter asserted. And the post should not come in. I don't know who posted it. It would have to lay a foundation for the writing.
So the fact that the posts were made and that they were publicly made is is the evidence itself, not that it's true. This death to the big homie sent the word
What-
out from behind the wall.
What would you have the answer generally be? I mean, what would you presume his answer would be, or your question and his answer?
were there threats made against YSL in the moments, hours, days following Donovan Thomas's murder? Yes. There were public threats, social media posts, and the like, and these would be them.
Okay, well, that would. Okay, yeah, and that would be overruled because it isn't being offered for its truth. Okay, but we can just do that at the point in trial. We don't have to have this slide.
Okay.
So it slides out.
Slides out.
Slide is out.
All right, slide 10.
It's a lot of slides in this PowerPoint. They're going to be doing this all week, all night, all the rest of this day.
Tell me, I guess, what I'm looking at and why he's going to be using this.
We can take this out. I think that this picture is already in any event.
All right. Slide 11. There's a lot going on this slide.
There he is. He can testify about that. It's basically Mr. It's the services of the victim in this case. So he can testify about it.
It's a good
Taking
question.
victim impact.
What would be the
Just-
relevance of how, many people were moved by his death?
Judge, if I may come back to the court on that, I can take out the slide and
Okay,
as to the questions about it.
all right.
So 11's out.
So the slide, yes, 11 is not going to be used, and she'll get back to me on the relevance of how crowded his funeral was.
He's very loved.
And maybe it is, I don't know, but. All right, slide 12. So. How about slide 12?
It's a similar one as the one earlier, so we can take out, we can take that out in the same way and introduce it if we need to. and-
Okay. Thank you.
So the motion that Brian
Is the
Steele
picture
submitted,
with the placards from obviously some.
hold on, give me 1 second, y'all. So the motion that Brian Steele submitted was about this slide. The motion itself is 110 pages. And only about maybe 3 or 4 pages actually have some actual literature on it. So it's about it's over 80 slides in here. I'm pretty sure.
Shooting already in evidence.
I don't think this particular one is, but it will be. We anticipate that this will be
Okay.
admitted in
Well,
evidence.
if you want to present it to him and ask him about it, that's fine.
Okay.
And the second one on there, do y'all intend to have him talk about that picture?
We can take that out.
Okay. All right, so then 13 essentially won't be used, and you can, if he can identify what's the crime scene photo, then he can testify to that. Okay, number 14.
Do we? So, Judge, we don't have to, with number 14, we would need to introduce, I think, the photographs versus putting it up.
Okay.
We would, yeah, as opposed to using it as a demonstrative.
Okay,
Producing
and
the
I mean, if they're
photographs.
already in, then obviously, if he needs to testify to them, he can, and if they're not in, you need to be able to Obviously, you need to be able to lay the foundation.
Right,
but-
and we may just get, some of the ones that are, as the court has already pointed out, some of the ones that are already in and put them on, just to use those as our exhibits with
Okay.
him.
Picture of him already. Picture of him.
I mean, presumably this shows everybody's, the relation, in a relation of these three people.
It does. He testified about that. It, but this is just like putting faces to the names and sort of family diagramming, and I think we actually did that earlier. So it would be referring back to something that's already.
I'd be objecting,
Then
Your Honor.
yeah.
the
Born and raised in
mother-
Detroit. What up, though?
If I
313 in the
interrupt, I
building.
apologize.
Yes, absolutely.
If the mother of Mr. Thomas testified to.
I do not
family
live there
relations, the
anymore,
Father of Mr.
but,
Thomas testified to family
because of my
relations.
career,
Detective
but
Dennis
yes.
testified. Now,
In
he may
Detroit.
not have, actually. He may not have. So definitely the parents, the mother and the father, I would be, it's just repetitive.
Okay, sounds like she doesn't intend to use this anyway, upon further reflection. All right, slide 16. We still have a current intent to use this slide.
We cannot use 16.
Okay. Okay, 17.
17. We can as well not use, so what, I think that what we'll do is just take some of the pictures, photographs that we've already admitted
Okay.
and use those as the exhibits rather than trying
Okay.
to introduce whole hog. this
Sounds
PowerPoint.
reasonable. So 18. Y'all still.
No
wanna
doubt, no
be
doubt.
on that?
Appreciate you.
No, we cannot,
Okay.
we cannot.
All right.
Well, except that I think that the photograph in the bottom right corner
Yeah.
were guns that were recovered. But I'll confirm with Dennis. I won't need so that might be something that we could use as an exhibit and not
Okay.
a slide. So it would, if there's anything in this picture, certainly not the top three.
Okay.
But if that bottom right picture, if we do anything, we would tender it as an exhibit versus trying to put it in on a demonstrative slide.
Okay. And these are all
It was the stuff that was collected from one of the vehicles.
from an alleged rival gang.
Yes, after the shooting at 1006 Hill Street. Actually, not the rival gang. This was the one that was collected from the people who were shooting back at the people who were shooting at.
Okay. Okay. All right. Well, I mean,
But
I can anticipate some potential objections from the defense at the point in time if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this is
Oh,
from
well,
the
we'll
other
see.
side. This is
We'll
the
see what
guns
the
from
strategy is.
from the other side.
We'll see.
Okay.
Okay. That's what makes trials interesting.
So 18 is out.
18 is out. 19.
19, we have not yet introduced that photograph, but I think that we've,
The one on the bottom, or?
yes,
Okay.
the one on the bottom. Part of that photograph is part of what was talked about in the interview with Mr. Copeland that has been shown to the jury so far. So we could definitely take out the word, we'll do whatever the court instructs, but that photograph, we can introduce it as an exhibit if it has not already been admitted, and we cannot publish the PowerPoint slide.
Okay.
And in that vein, Judge, with respect to, since we're going through it like that, rather than introducing, no, I think maybe we should. I was gonna say, rather than introducing the whole thing as just, here's his demonstrative that he's using, since we're cutting it up and using parts of it, rather than saying, okay, we're gonna use this, we won't use the PowerPoint.
Right.
We'll use exhibits that either have been admitted or
Okay.
that we tender through
Okay.
him.
All right. And so that'll be true for the rest of this?
Yes.
Okay.
So the whole PowerPoint's out.
Well,
Am I hearing that correctly?
we won't use the PowerPoint.
Yes, she's just saying it's gonna be easier not to, because I mean, I would imagine he's probably kind of like press play and he's like, here's what happens in slide 1 and slide 2. And if he's not doing that, then it might be easier to do it another way.
Right.
Okay. All right. So then I guess as for the rest of it, we can keep going through with regard to the pictures themselves, or you can just, if there's some if there are some pictures depicted within the slides that the defense thinks are particularly egregious or objectionable that you want to go ahead and alert me to, that's fine.
Or worthless.
Otherwise, I guess we'll just see what happens at trial.
Your Honor,
Yeah.
wouldn't the same rule that your court said the state now will give us what they believe they're going to introduce as an exhibit through Detective Dennis, and we could raise it with you?
Yeah, that would be helpful. I mean, you're going to want to take a look at this and then decide what you actually want to use. So once you kind of narrow that down, if you'll just let the defense know which ones you actually want to use, then they can raise any kind of objections that we could get taken care of outside of the presence of the jury beforehand. That's fine.
So
Thank
can-
you.
Can I just make an observation
Sure.
or an objection? So before this honorable court took over, there were lots of objections as to, it was Detective Dennis allowing to say his investigation. So not a witness came in, the crime lab person didn't come in, just he was allowed to say, I learned of, and these CAD reports, I objected to everything on confrontation clause and hearsay. And the former judge denied it. So it all came in. I think the state, is about to do the same thing with the same witness. And I will be objecting again. And I also have this section. I'm looking for Georgia cases.
Okay.
It says, this is, I have a couple cases. This is United States versus Nguyen, Nguyen, that's wrong. 504 F 3rd, 561, 5th Circuit, 2007. Thus, while summary witnesses, which is what I call Detective Dennis, may be appropriate in complex cases in certain circumstances, they are improper for introducing evidence that the jury has not previously heard. We repeat our admonition that the government may not use summary witnesses for inappropriate means. While such witnesses may be appropriate for summarizing voluminous records, as contemplated by Rule 1006, rebuttal testimony by an advocate summarizing and organizing the case for the jury constitutes a very different phenomenon, not justified by the federal rules of evidence or our precedent. So to me, this is what I call a summation or a closing argument. And I know that the court struck it. So I don't have the same exact situation as my motion to exclude this, but this whole thing is a closing argument. This is PowerPoint was a closing argument. I understand it's no longer like that. It's dismantled and now we're going exhibit by exhibit and rulings. But my point to the court is if you can just, I'm not asking for an advisory opinion, but this is going to be There's 2 Detective Belknap, 1 Detective Gaither, maybe 2, but 1 Detective Gaither, I remember, 1 Detective Dennis. They've all been over objection, qualified as experts. They're on the exact same situation. And now we're going to replow. Detective Dennis already testified as to the alleged back and forth. He already said all this. So did Detective Gaither. It's all over objection. But I would object that it comes in now again.
All right.
Right.
What would be, what's he gonna be talking about new? Why are y'all presenting him again?
So because he's sitting through some of these, specifically some of the interviews that we are
Okay.
talking about, some of the actual shootings that we're showing the evidence of, like on April the 28th, the Hill Street shooting. He touched on them. We did not get into, like, he as an expert talked about what their investigation led them to do and sort of what their investigation entailed. He didn't talk about the details. We won't be getting into rehashing something he's already talked about. The stuff that he's going to deal with now is going to deal with specifically the interviews that he conducted, depending on what the witnesses say. If there are some instances where, we don't need to play the interview because they say exactly what they said, then we won't do that. But we're
But it's
at a different
hearsay
part.
still.
He is a fact witness, and he's still he has still been qualified as an expert by the court. So we won't be rehashing stuff that he's done, and we won't be using. I'm not certain when Mr. Steele says, he objects to summaries. As experts, they're allowed to talk about how they arrive at certain conclusions.
Yeah, I think there were maybe like a couple of different objections in there, but it sounds like one of the objections or potential objections would be if he's going to get up and basically rehash the same thing he already testified to about
There you-
how,
there you
the
go.
whole, the theory is that all of
Cumulative.
this came about because it was the culmination of, some gang wars, basically.
We've already
That's
dealt
already been covered, so he should not be testifying to that again.
right. We don't need to, but specific, like the April 28th shooting, the Hills, like we haven't put up all the evidence in some of
Okay.
them.
Nobody in here is being charged with that shooting, right? That's part of the story of some of the crimes that are charged in the indictment, right?
I think the court is saying that they are overaxed. Some of them are overaxed that are listed in the indictment. If that's what the court is saying, the answer is yes.
Okay. So I may be thinking of the Hill Street shooting as something other than what it really
The
is.
Hill Street is not. The Hill Street is not.
Right. That's when Woody and his girlfriend get shot at, right? Or no? Okay. All right. Sorry. There are a lot of shootings that I haven't been in this case the whole time. So, all right. So, but I guess, so let's take, for example, that one. I mean, we're not going to need to get into the nitty gritty of that one because that one, all that we need all for the jury to know for that is it happened. Some people believed it was a rival gang. It, made the beef worse. We don't need all the details about how many bullets were found, right?
That was free to read. That was Lucci's mom. And so
Well, that was another one. But
so the overacts connect that shooting with the ballistics from that
Okay.
shooting.
Okay, so for that reason, that might be relevant. But-
And Lucci's a central sort of
right
opposition figure in
Okay.
the whole.
Well, I guess I'll just have to take them as they come, but we do not need a whole entire like crime lab. Here is, what you would put in if you were the state prosecuting that shooting when that is not an overt act and it is just something that happened along the way that's part of the story. I don't want us to be having a mini trial about that.
And we've scaled back everything
Okay.
in the indictment, even like we were saying yesterday with the Rodelius Ryan murder.
Okay.
We've scaled everything down.
Okay.
Like that. So
All right.
it's not to.
So are there other objections encompassed within what you just said, Mr. Steele, that I need to be addressing?
don't see why Detective Dennis, through his investigation, is allowed to say, oh, there was a Hill Street shooting and this was gang related, or this was done by this gang in retaliation of this. And we linked up later through the GBI crime lab, a weapon that was used in this shooting and another shooting. You know, to me, that's all confrontation clause. And the investigation doesn't matter. They could have done the greatest investigation. What matters is that the state put up competent evidence before this jury to determine the charges and the elements in the indictment. So to me, it doesn't matter what their investigation was. Now, I have challenged the investigation that they did not verify or corroborate. I have no problem with that, saying, well, I did verify and bringing in the witness, or who the witness was that they spoke with. Maybe not what they said, but what happened last time with the predecessor judge was, over objection, Detective Dennis and Detective Gaither was able to say, oh, we verified that this happened in relation to this, and this happened because of this, and this started a chain with this. And this whole thing started in the fall. By September 2014, there were no witnesses here.
Okay, well, I mean, that's the subject for cross-examination then.
It's hard to cross when I have no reports. I have no reports. I have no expert report. I don't know who to interview to say, no, that's not true. I never told them that. In fact, I told them something different. This is all to me like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And I've asked for reports. Judge Glanville told the state to produce it to writing. This is all confrontation clause, and it's all coming in as a conduit through some, quote, expert. And it's come through with many experts. And to me, it's just like not having a trial.
Okay, well, I'm sure you'll be able to undertake an effective cross-examination of this and every other expert witness. I have been told since I've been in the case in front of y'all in court that there aren't expert reports. Does that continue? And y'all were going to circle back and ask whomever over at APD to do an exhaustive search, even if people were retired. What happened from that? Has that been conducted?
For police reports, yes, we were, actually, I think the court told us to do it for a specific act, and I can't recall which one it was, and we did. And there wasn't, but we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
okay, you recall that I did tell
The side eye
y'all
was crazy.
to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right?
Yes.
Y'all did that?
yes, and
that
you
produced
did.
nothing?
No, we have
Okay.
nothing that we haven't turned over,
All
because
right.
what we did, what the court required us to do was, it was for a specific one.
I don't think it was.
Hold,
I mean, it may have been for a specific one and then everything else. But anyway, if it wasn't done for everything else, do it for everything else right now.
Your Honor, could we take a very brief restroom recess?
We just had one less than an hour ago. So, no,
I'm
sorry.
Okay, I apologize. Mr. Atkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes,
Yes.
we don't have anything extra. We will go back again, because I've gone over and asked homicide. I've asked gang. I've physically gone over to the gang unit, physically pull out boxes of stuff. I will continue to inquire.
All right. Well, I don't know that, the best use of your time is to pull in boxes and look through them. That ought to be what the police are doing, but you need to direct them to do that.
Yeah.
And so with regard to the gang experts, did y'all go back and say to somebody over at APD and in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I
and
know,
that's
but
what-
then I ordered you to, so did you do it again?
Okay, so
Because I ordered you to.
Well, look at Love. She always looking at Hilton.
we have not inquired a second time, and I apologize to the court. We're gonna do it again. I will do it.
I pretty
personally.
clearly told you to do it again.
That's what he's reminding me.
Yeah, well,
So-
Mr. Atkins, you could have done it.
Well,
Yes, Your Honor. I'll go make a phone call now.
Okay.
And can I mention something?
Oh, this is
Came
some
out
bull.
During trial, during a motions hearing, that there is what I'm going to call a black book. And it's all the gang information at
Yeah.
AP. Okay, you seem like you know about it.
I've
Well,
heard about this before.
okay, well,
Yeah.
I don't know about it. And we were told, we were given the Heisman. We were told that we're not getting that. Detective Dennis said he no longer works at APD, so he has no access. Detective Gaither said the same. Detective Belknap, who continues work there, says that's not for public information.
Well, I would imagine it is not. However, if such a thing exists, do y'all know what Mr. Steele's referencing?
If he's talking about what Detective Dennis said that he used in the beginning of his career as a law enforcement officer, where he collected information, I think maybe he called that maybe a black book. I don't know if he's talking about that or if he's talking about the information that they keep on gang members. I'll let him clarify, but.
All right. Do you know, Mr. Steele?
I'll take anything that has to do in any way with the testimony in this trial to either be able to go and interview the witnesses, confirm the witnesses. There was a lot of talk over objection. The policy of APD, how they qualify somebody as a gang member.
Oh.
It's self-admission. It's somebody else who's reliable, would say that they're in a gang.
Okay.
They hang out with somebody. All that's in this supposed book. I don't.
Okay, that's entirely different.
Okay.
Just-
So you now do know what he's talking about?
No, that's entirely different. Detective Dennis talked about, and Detective Belknap talked
Mhm.
about how they identify gang members
Okay.
and what criteria they use.
All
It
right,
is
is
not
that
true
something that is in
something in a
writing?
black book.
Well, whatever. Is it something in writing?
I can I
No.
think that the criteria,
Okay.
those criteria that they use, that is something that is a written sort of criteria,
Okay.
and I'll get
All right,
that.
let me propose, if that's easy to get and they don't have kind of security concerns with it being provided to the defense, then
That's
provided
not
if
true.
they do have security concerns, then it can be satisfied by saying, Mr. Steele and anybody else on the defense team, you can come look at this written policy, at 12 PM on XYZ day over at APD. That satisfies it also. So in some way or another, if there is a written something that is how they classify, then give them access to it in one of those ways, okay?
The Gossip Girls are upset with each other, dog.
That we've not already given them standard operating procedures as it relates to
Okay.
gang unit.
Well,
and gang
obviously, if they've got
identification.
it already, then they've got it.
But in terms of being able to cross-examine the witnesses on specific incidents that they've discussed, we've turned over entire files relating to each of these incidents.
Okay. All right. It
This is
sounds
so
like
crazy.
what Mr. Steele's talking about is the sort of policy that you just mentioned that are the
Who
guidelines. the
what
criteria.
police department has a policy of recognizing a gang
They
member
spoke with, they're talking about.
All right. Well, they may or may not have any.
without it being
Yeah.
an assumption, a
Well,
And you can
speculation, or
always
anything?
just interview the detectives
Well,
to ask them those things.
well, I have interviewed the
Okay.
detectives, and they tell me that they're not releasing that information. They would speak with somebody. They'd speak with Brian Steele. Brian Steele would say that Keith Adams is not involved in criminal street gang activity. That would go into some sort of book. And they would speak with Carlton Matthews, and he would say that Brian Steele is in a criminal street, and that would go in some sort of book. I'd like to see that because they're speaking about, we corroborated this. So I asked on cross, who did you speak with? I'm not going to
Look at the arguing.
Well, why don't I have the right to know?
I don't know. Maybe they consider them confidential informants.
He never said,
have to
I'm
get-
not. I don't
There
think
no
he ever said,
confidential
"I'm not gonna
informant.
tell
Judge, you need to
Judge, I
shut
think
your
I
mouth.
was-
I'm not going to relitigate it. If it comes up again, we'll deal with it then.
Oh,
Okay.
the Gossip Girls are not
So
in
I'm not
sync
even
with each
sure how
other.
we got on that. Oh, but Mr. Steele, you've said a couple of different times that you object to certain portions of CAD reports as
She over
being
it.
hearsay, and you were going to get me some law about that. And I don't know if other CAD reports are going to come in or not, but. Okay, well, provide it and that way I'll,
Hey, chat, go ahead and caption
and
the,
provide it to the
name of
state
these
as
girls
well,
right
because
here.
if it's
I call them the
clear
gospel
law, then
girls.
they can just
She Lee call them
redact
Cagney
those
Lacey. What y'all
portions
call
of
them?
CAD
Let's
reports
go ahead and do
might
this real
need to
quick.
come out as hearsay. Okay,
So I have KAMUSOKO versus state.
I'm sorry, start over. I
Okay.
just didn't get that at all. KA,
KAMUSOKO
okay,
versus state 362 Georgia Appeal, 276 footnote 3,
and what does it say?
868 Southeast 2D 252 2022. Says,
Breaking it down with B, say Thelma and
County
Louise.
SoCo makes no distinction between any
Like
particular
Dumb and
statements
Dumber.
and declarations, and therefore has abandoned any challenges he may have regarding particular statements
Let's go,
or
chat.
declarations. There is nothing for this court to review where the appellant has failed to identify precisely what statements he challenged. In addition, although SoCo mentions in passing that whatever was said to the 911 operators was filtered through people who did not testify at trial, he fails to include either citation to authority or meaningful legal argument that the CAD reports were inadmissible because the 911 operators or other persons writing down the declarant statements did not testify at trial. He therefore has abandoned appellate review of any challenge to the CAD report on this ground as well, and that ground is hearsay and confrontation clause. It's in Division 2 of that opinion, but I read
Okay.
from footnote 3.
All right, so, I mean, that doesn't establish that if objected to, it would have been an objection with merit. It's just saying, hey, you're raising it on appeal, you didn't raise it below, we're not gonna deal with it.
But it's right, but the CAD
So,
report
okay,
could be
maybe you could come up with one that
Shout out to
instead
Ashley
of
G. She
saying
say
this
pinky
is a
in the brain.
potential issue, says, all right, here's the issue, and in addressing it, here's the law on that. Can you try to do that? Thank you. All right, okay,
in this case, in Division 2A,
all right,
where the footnote 3 is,
okay.
and what the court said was it's admissible under an excited utterance of hearsay. It's
Yeah.
hearsay with an exception.
Right,
So
okay.
my point is, some CAD reports they don't identify an emergency situation. So they're identifying a past event. So that would be a confrontation.
Okay,
clause.
well then, you'll just,
It depends
if you
on the
plan
CAD.
to make that objection to every CAD report, then give me the CAD reports
Right.
and I will make a ruling.
That's right.
All right, let's do that. So that can be on the agenda for tomorrow. Okay, thank you for clarifying that. I do realize that there might be times, I just thought y'all had some kind of blanket, this part of a CAD report is always out. And that is not what we have.
Right, it's like a
Okay.
911 call. It just
Yeah,
depends
no,
on the-
I'm clear now with what you're saying. All right, so we've done the PowerPoint. So I am going to give us another quick break, but I'm gonna say, and I'm gonna say this once, and I don't want to have to say it again. And this is kind of what you say to little kids when you're on a road trip with them, is if we're taking a bathroom break, even if you don't have to go right then, if you could hold it for another 40 minutes, just take the opportunity to use the restroom so that we don't then 30 minutes into court again, have to take a break because now you can't hold it anymore. Okay? All right. So we'll have a little recess.
Judge, another recess talking to them like little babies. I'm sick of her, man. I am sick of her. Shout out to the chat, man. It's been look again, Cagney and Lacey, Thelma and Louise. This is referring to Hilton and Love, Dumb and Dumber, little Pinky in the brain going on. Laverne and Shirley once again. Now Ike and Tina. Flesh of the gods, dog. Let me guess. Love is Ike. Flesh of the gods. You got to confirm that, dog. Is Love Ike? Oh my goodness. Oh my goodness. Yes, that's a great one, dog. That's a great one. Love got to be Ike on that one. Love got to be Ike on that one. Dude. Oh God. Oh, too true. So I'm so sick of this judge too, for real. I mean, seriously, like, what are you talking about? You know, man, you talking about you got defendants in your courtroom that they're locked up all the time. You know what I'm saying? Like they go through stuff, man. So if it's them, excuse me, that needs to be take care of some business, then they need to take care of their business. You know what I'm saying? Flesh of the guy says she be telling Hilton to eat the cake anime. Eat the cake anime. Eat the cake anime. All right, let me do something real quick. All right. Let's go ahead real quick. All right, I'm about to blow this up. So this is the slides that they were looking at. Okay. And slide 1, they want to implement this entire thing. And these are the slides they're looking at. Tattoos. Remember, these are the pictures, all that kind of stuff. And it's all cumulative. It's like, okay, we know that they all know each other. So all this stuff is cumulative. We already know about the beef between Woody and Shell Kill. We ain't got to go through this. We know about that. This don't mean nothing. This is just a picture. This is just what they used to do back in the early 2000s, the 2010s, in the 10s, in the early 2000s, man. This is what dudes did in the streets, man. They had money and they put the middle finger up. I mean, this is who is it directed towards? It doesn't state. He just got money. He just got money, and the thing, and then flipping the bird, and then he got the Rich Gang shirt on. You know, then we know about this. We know who Big Nut is, or Peanut. We know about we know like these things right here is just irrelevant, cumulative. You know what I'm saying? This has nothing to do with anything as far as like charging them with anything or trying to prove any evidence in a case. I mean, this is nothing, you know. And so these are the slides. These are the slides, man. Look at this. Look at that. Look at this up here. 25 out of 110. Let's see how far this goes. Okay, we saw that before. We saw this, right? Of course, we know that they know each other. We know they all know each other. We know this already. So all of this has exactly time. Exactly. This is my question right here. What does any of this have to do with RICO? Honestly, what does any of this have to do with RICO? Be careful. They gave me limited monetization. Really? Oh, okay. All right. Well, let me go ahead and digress. Let me go ahead and digress. Oh, that's right, because the images of the artists and things like that. Okay. I see what you're saying. Yeah, let me go ahead and digress. But again, what does this? Thank you, Flesh. I appreciate you. What does any of this have to do with RICO in particular? Like, seriously, what does that have to do with anything? You know what I'm saying? And so it doesn't have anything to do with anything. And that's the whole point. That's the whole point. You know what I'm saying? See here, let's see what's going on Thugger Daily real quick. Let's see here. It's actually, I mean, this is the okay, Thugger Daily put up the PowerPoint on his X account. Sheely said, Rico said, my name Wes. I'm not in this mess. That's old school. That is old school right there. That is old school right there. That is old school right there. Too True says, heck, they still don't know who unalive Nut. It was a cold case. I think that's another point, that another reason why you know, when it comes to Paul Howard under his administration and all that kind of stuff. It was like it's a cold case, basically. They still don't know who did it. You know what I'm saying? They still don't know who did it. I'm gonna TiVo the action real quick. I did pause for a second, but they don't know who actually did the actual shooting or anything of that nature. They don't know who unalived Mr. Thomas. They don't have any evidence of that at all. You know, Paul Howard was not going to bring this case to the public because there wasn't enough evidence, and he did not trust Woody. And I believe that is something that Miss Merchant, Ashley Merchant, spoke about in her interview with Professor Nez. We don't know. We don't have enough evidence to state whether or not who unalived this human, this person. So we don't have enough evidence. We can't just go off of testimony because, again, Woody states all the time that I lie, man. I lie about everything. I lie about. I'm a lie on you. If somebody tell me, hey, tell me something about Miss Hilton, he gonna give him a whole story to get them off of him. That's exactly what he said. All right. So it makes no sense. It makes no sense to utilize a person like that as your basis of a case. You know, even though the whole Club Crucial situation involved him and Kel or whoever and all that kind of stuff. And that was the leading to, you know, what happened on January 10th. However, it had something to do with also implementing the fact that, you know, Nuts stuff was missing or something like that. And he brought it back to him or whatever, that he didn't like the way Nut looked at him, all that kind of stuff. Like all these little nuances, man. Like how can you build an evidentiary case with hard concrete evidence? How can you build something off of that? You can't. You got to have, there's a difference between being a witness and being an eyewitness. Where's the eyewitnesses? You know what I'm saying? And the ones that were actually there, that's the defendants or whatever, they're not giving up anything. They're telling you what they heard. They're telling you what somebody told them. That's not anything. Tay Biz, so Nut only had beef with just Young Thug. I find that hard to believe. Exactly. Like he was just like that was it. I don't think so. Again, they like to lie to us, man. They tell us anything, and we're supposed to believe it. I don't think so. And then with Woody getting on the stand saying, hey, I gave threat vehicle, you know, all this kind of stuff. I did this, I did that. Like, he finally being truthful. What he said, that's what he said last week, Monday. Y'all want me to be truthful. Now I'm being truthful, you know? So yeah, it's all bad. It's all bad. You know what I'm saying? There's nothing that that the state has that's credible. Even their evidence is social media photos that's been posted. Look, like social media photos that have been posted. That's what their evidence is. You can't go off of that. I mentioned metadata, right? And so let me just give you a real brief definition of it right quick, because again, this is the reason why even the social media images should not be submitted as evidence of anything as far as like the time frame of things, because they submitted a photo, I believe this was yesterday, where they brought up a photo of, I can't remember who it was, looking out in the city, and I think it was like a day or two after Nuts unaliving, and they posted it as the time, they trying to put the time frames together. And so you can't do that from a social media post. We had somebody in the chat yesterday, I believe it was Red Bunny. She said something about the fact of, man, I went on vacation about a year ago. I haven't even uploaded my vacation pics from a year ago yet. You know what I'm saying? And she plans on doing it, is what she said in the chat. So let me tell you something about phone metadata. And I've done this before because I'm in IT, I'm an IT professional. I've done metadata before for emails and files and everything. So metadata is very, very specific. It's very, very important. It's very concrete information. So photo metadata is a set of data that describes and provides information about an image, It can include information about the image itself, the camera settings, and other details, such as image information, the orientation, exposure information, the title, the caption, photographer's name, and legal notice of if it's a copyright ownership on the photo. That's what metadata does. Shutter speed, aperture, ISO setting, and the camera and lens used. It gives you information about the date and time the photo was taken. The date and time the photo was taken. Just because somebody posted a photo on Instagram or on Facebook, it doesn't mean the photo was taken that day. So you got to get the metadata in order to say, okay, this photo was taken this particular day and it's associated with this particular thing. All right. GPS coordinates for the location and contact information. So when you hear stuff that people talk about plotting, like the IT professionals who does like cellular data and all this kind of stuff and cellular location, and they do plotting and all this kind of stuff. They're gathering all the information possible to show a person's location, and they're utilizing different type of tools. Some people use SailHawk. So, you know what I'm saying? There's a lot of different tools, but SailHawk is like one of the most advanced ones. But it gives you the metadata of photos. It gives you the metadata of certain things. So the fact of the matter that they're trying to use social media postings as, okay, they posted this and it was around the same time that this happened. Now, if you want to use social media posts or photos to declare that these people know each other, even to that extent is going to be a little bit hard to prove, because you don't know how they know each other exactly. You know, so even if I took a picture, let's say for instance, I took a picture with somebody from the chat, and then you post it on Instagram, and somebody say, "Hey man, you know Tay?" You be like, "Well, yeah, I know. Yeah, he a YouTuber. You know what I'm saying? He do whatever, da da da." But I mean, like, how long you known him? I just know him from YouTube. You know, so that you can't be used as someone who knows me. So you can't be a character witness and say, "Hey, I know this guy. I know him because I know his character. I've been around him. I've been around his family. You haven't done any of that. So just because two people are together doesn't mean that they know each other all the time as well. It's a lot of times where people take group photos with each other, and in that group, a lot of people may not know each other personally. And see, you talking about the court of law, you got to be specific. What do you mean you know them? How do you know them? Y'all done broke bread? Y'all done been around each other's family? Y'all done been on vacation with each other? Y'all have a personal relationship? How long have y'all been together? How long have y'all known each other? How long? All those things matter. So if you take a photo face value wise, you're never going to be able to prove anything. Not to that extent. But if you get the metadata of a photo, if you get the metadata, it'll tell you where you was at, when you was at that place, that area, and what time. It'll tell you, even if it's and I mentioned this yesterday, I believe, with the Amber Heard and Johnny Depp case. Amber Heard put her photos in Photoshop to make it look like she was getting hit. Telling you, man. She put her photos in Photoshop to make it look like she was being abused by Johnny Depp. And these photos was so doctored up. Anybody could tell, like, yo, that's Photoshop. It was only when an expert who specialized in metadata for files, photos, or any type of file, photo would be a file. Once he extracted the metadata, it showed the iPhone that she was using to take the picture, but it also showed that the photo that was being used in evidence was from Photoshop. So you took it with you took it with your phone. You took the original picture with your phone, but you put it in Photoshop, which is Photoshop has a mobile app as well. You put it in Photoshop, and you started to doctor it up right then and there. And then you said, okay, we're going to use this photo. You saved it. You saved the photo. Then you're going to use this photo for evidence. See, that's what the state is doing. The state is basically gathering social media photographs just to say, oh yeah, they all know each other. And that's cumulative. We already know that. But when you say this person took this photo the day after Nuts shooting, okay, you got to have metadata to prove that, not a social media post. Not a social media post. And so that is the problem with the state. They don't have anything concrete at all. And this is the problem with this whole case. This is the problem with this whole case. Too True says, seems I remember saying in the secret meeting, y'all want me to say I unalive Nut, and the state said no. Exactly. The state told Woody, don't you dare. Don't you dare say it. If you say it, we gonna impeach you. You know what I'm saying? We're gonna impeach you, and then you'll be in jail. You know, but then he said, what? I did these crimes. That's what he said, right? That's exactly what he said. Tom said, Love and Hilton with Atkins makes Three's Company come and knock on my door. We've been waiting for you. Time, dog. It is hilarious. Mimi says, Time, I don't understand why defense hasn't looked into all ops Nut had. Exactly. That's a good point. That's a very good point. It couldn't have been just Thug. It couldn't have been just Thug, man. That's a great point. All right, we're back in court. Hopefully they don't have no more breaks, man, because this is just ridiculous. Because I do want us to look at Brian Steele this morning when he went to the Supreme Court. So metadata is a process or a program. No, metadata is the information that's used through a tool. Like for instance, if I'm an Outlook administrator for Microsoft, I can go into
we
the
can move on
metadata
to
of the
another
email through Outlook and find information.
task.
So
on
you
our
utilize a
task
tool,
list.
and this tool extracts metadata,
Open
Mohawk
suggestions,
or
or I'll pick one.
other types of tools. And then that program helps you
I
to
know we
pick
still have to do
the data. So
the
that's what that is. So metadata
excerpts
is
from the
very, very important.
wiretap evidence.
They have not presented that at
So
all.
that might be a good thing to turn to next.
All right. I'm gonna be quiet.
Yeah.
I meant to bring this up yesterday. We've been labeling the excerpts from the wiretap as potentially co-conspirator statements.
Right.
And I think the state announced that those wouldn't be coming in until Investigator Viverito testified. What I meant to inquire about the other day was, I know that they've suggested that there are additional co-conspirator statements. I'm just wondering if any of those are linked with witnesses coming up soon.
Hang on just a second. Nobody say anything because our court reporter needs to plug in back up.
All right, while they're doing that, Too True. Programs like Aliation, Calibra Data Catalog, Adaptive Metadata Manager, Cellhawk, I've mentioned that before. Oracle Enterprise Metadata Management, like IBM Knowledge Catalog, Informatica, Data Hub. Like these are tools that you can use to get metadata, to get specific information about a photo, a file, or something like that. So that is how you are able to extract the metadata through these particular tools. Data.world. A lot of people use open metadata. But yeah, these are tools that you can use to get that type of information. And that's the kind of stuff that you need in order to say, oh, this person took this picture on this particular day at that particular time at this particular location.
Our court reporter's still rebooting, so thought you might have something that was not something we needed to take down. Okay.
Some research to do on our case tomorrow. So with Mr. Williams' permission and Mr. Adams' permission and the court's permission, I was going to do that at my office. And I will not be here tomorrow, if that's okay with the court. And Mr. Williams said that's okay with him. He could speak for himself, and Ms. Adams said that's okay with him.
All right, sounds good. Thank you. Okay, we're back up now. So I don't know if all of what Mr. Sharp said got on the record. Do you mind just reiterating it?
So, yes, I will. We put off, we suggested that the wiretap co-conspirator statements are going to come in through Investigator Viverito, which would be later on in the trial. But I believe that the state has also stated that there are additional co-conspirator statements or alleged co-conspirator statements that are not part of the wiretap. And I was just suggesting if those involve witnesses that are coming up sooner, that might be something that we need to address.
Okay. Do we have other co-conspirator statements that are not the ones from the wiretaps coming in through to Investigator Viverito?
So, since we won't be getting to the wiretaps until she's number 91, witness 91, in terms of, okay. My question to the court is, would the court allow us to go in order of the witnesses that are coming up and deal with the buckets of
Yeah,
exhibits?
that's fine. And I think that's kind of what the defense might be trying to figure out is, do we have some co-conspirator statements that are going to be coming up soon? And I'm fine if it's easier to just say, okay, we're talking about co-conspirator statements now and tackle the ones that are coming up soon. That's great. Or if we want to go witness by witness through, here's the evidence that's going to come in with this witness. I think either way makes sense, but let's do one or the other. So yes, it sounds like maybe there are some other co-conspirators or alleged co-conspirator statements that are going to come in soon.
Not any that are coming up soon, not soon.
Not soon.
The witness buckets would be the most. The next, Jamari Holmes is the next time that we'll have co-conspirator.
Can y'all all
statements.
hear her?
I'm sorry, I'll get closer to the mic.
Okay.
Jamari Holmes's murder is the next time that we'll have that issue. And that's the one that we were discussing at the beginning of court with Your Honor and
Okay.
Mr. Williams and Ms. Sabas.
Okay.
So the co-conspirator,
That's a little ways away.
yes.
Does that answer your question?
I'm fine with that answer. As long as nothing sprung on us at the last second with these witnesses coming up, I'm fine with that answer.
Okay, so they do have what those co-conspirator statements are, right? We don't need to litigate it right now.
I'm sorry, I missed what the court.
Do they have whatever the co-conspirator statements are, whether they're from the wiretap or a different source? Do they have them all?
Yes.
And have they been identified as potential co-conspirator statements?
Yes, Your
Okay.
Honor, for the most part. Just 1 second, I'm going to confirm one thing.
Okay.
Hilton and Atkins is getting in there. Dang. Look at this interaction here, man. I mean, they really going at it. My boy Left Hand got upset too. Left Hand had to cover his mouth like, man, I wish you would just hurry up. I wish you would just get off this case, dog. Everything you do is stupid. Everything you do is just so stupid. I'm telling you right now. I want to quit. I want to quit so bad. Oh my God, I want to quit. I can't stand you. You know what? And another thing, you know what? You smell bad, by the way. You know. That boy Left Hand had to cover his hand. He could have covered his face. Scarecrow, Tin Man, and Gary Line. Dumber versus dumber. Oh my goodness. Look at the judge. Judge like, y'all finished? Y'all done?
Sprinkles folder have potential co-conspirator statements in them. We don't have them extracted out. We just have the ones in there
Okay.
that we intend to use.
All right, I mean, y'all ought to be aware that if there are jail calls by co-defendants, that those might contain co-conspirator statements. So that would be the only thing that might not be specifically identified. Is that okay?
My expectations are correct. In line with
Facts,
the
Vaughn.
courts, the state is going to specifically identify those alleged co-conspirator statements. Correct. I mean, there's thousands of jail calls from probably, I'm underestimating, well, thousands, yes. So we would need to know what statements, when they're made, between whom and whom, if the state, because we would like to litigate these beforehand. I know the court would too.
We put in the Mike Sprinkle bucket, the jail calls that we're using.
All right, so jail calls y'all intend to use are all in the Mike Sprinkle folder?
The ones that we have identified that we intend to use, and those are the ones the court told us to.
Okay, so the universe has been narrowed, hopefully substantially. I haven't looked to see how big the Mike Sprinkle folder is, but
If it's the same one that I think they're talking about, it's about 200 calls,
okay, well, then,
15 minutes each. So that's 50 hours of.
okay. Which
said
I
no, it's not.
presume is one of the reasons y'all said, let's hold off on dealing with what's in the Mike Sprinkle folders.
They are arguing.
So as the state, look here, as the state is itself going through the Mike Sprinkle bucket in further detail and identifies for itself the specific co-conspirator statements that it intends to introduce, please identify those as well to the defense. As soon as you know, let them know.
So we have 14 in the Shannon Stillwell folder. We could start there since that is his client, Mr. Shart's client, that we could actually review.
Okay. Let me get some clarity. So in
Left
the
Hand and
Stillwell
Hilton has had it with this
of
woman.
jail calls, are those already identified? Just here are the co-conspirator statements, or are they just like, here's a 15-minute call, here's a 5-minute call? All right, and do you know what portions of those calls yeah. All right, but whether you've broken them out or not, do you know what those are?
Yes, that's why we put those 14 in there.
Okay, so if that's what I'm saying, is once you know, here's call from January 2nd, that is 15 minutes. I'm gonna use minute 2.5 to 2.9. That's the part I care about. When you know that, let the defense know that. Okay, so if you know that already, instead of us sorting it out here live, give that one of y'all sit there and type it up and send it over. They can look at it tonight. We can deal with it tomorrow. Okay. And similarly, do that for everything else. All right.
Facts. Stay unprepared in real time.
So that it sounds like the most productive thing to move to next, unless somebody else has a different idea, I'm willing to listen, is to just open back up, the witness folders and move on to whomever the next witness other than Mike Sprinkle is going to be, and go through that proposed evidence for any kind of evidentiary issues we can hash out now. All right, let's do that.
Oh man, this is catch up week for the judge. I promise you.
Why do I hear something? Dropbox link we were working from yesterday. That is the Dropbox link of the first 30 witnesses. So if everybody can find that again. Bless you. It's not easy to find it because sometimes instead of y'all giving each a new reline to your email, you just tag on to one that already existed. Get to it. There are many, many different things to open.
Eighth, 2024 email from Mr. Atkins.
I'm pretty sure that's right, right?
Yes, Your Honor. It says 30 witnesses and then it has 8 August 24 in parentheses.
All right, y'all let me know when everybody's there.
Miss Love has single-handedly messed this case up for sure. For sure.
Is everybody there now? Almost. All right. I'm waiting on y'all to tell me if you're there. All right, is everybody there? Has everybody got the 1 through 30 Dropbox link up?
We have the full, Kendrick has the full.
Okay,
I don't know about you.
great, thank you. All right, I've heard from 2 of 6. Y'all ready? Okay, 3. Stay ready. Okay. Mr. Matthews, you got it? All right. Who else? Are you ready, Mr. Sharp? Okay. Mr. Adams or Mr. Steele? Okay. All right. All right. Here's the one we're waiting on. Okay. You will catch you. Okay. All right. I think that we yesterday had gotten, other than Mr. Sprinkle, through. There was nothing with regard to any of the phone custodians, right? Sure.
So this link from the Dropbox is the link that has Mr. Sprinkle's folder in it. And they're going to go and unpack that and figure out what stays and what goes. Is that what we're doing right now? That's what it sounds like. I'm looking at left hand, click on some stuff.
Sure. All right, so the question on the floor was whether there's anything we need to look at with regard to any of those 3 cell company custodians.
As to those records, we can just bring in the records themselves and save that time, but
That would be nice. How about it? Miss Westmoreland doesn't want to. Okay, no, that's not going to happen. All right. Well, so we'll have 3 more witnesses, but with regard to the evidence within those, any kind of motion and limine type issues we need to deal with on those. Thank you. Okay. Then James Burney is the next witness listed. Do we need to look at anything with him?
Expert from the FBI phone records.
Okay.
And this is one that I voiced an objection to repeating the testimony because Agent Racy talked about for a long time where the phones were located. The prosecution stated that based upon questions by some of the lawyers for the accused, that they needed to do something else. I'm still holding my objection because I believe it's going to be, I looked at the report, it's the same thing, maybe a little nicer because it was done nicer. And I don't mean to insult Detective Racy. He didn't have like a chart, but I just believe that it's the same. And by when the same, I'm talking about the April 26, 2015 shooting of the tour bus of Mr. Carter, a performer known as Lil Wayne. Otherwise, no, I don't have any issues with with
Okay.
Agent Burney.
All right.
And Your Honor,
Yeah.
per the court's guidance, this April 26, 2015, we are not discussing the Special Agent Bernie. This, when he speaks on specifically the January 10th, 2015 murder of Donovan Thomas, that's the only cell records he's going to be testifying to.
My
right
boy
now.
left hand.
Does analysts or analyzes cell site tower data for other acts in this case and counts. So he's one of those witnesses that testifies multiple times when that act comes up. So what Mr. Steele, specifically the April 26, 2015, we will not be
calling him for that purpose.
correct, Your Honor.
Okay, but so when he's called here, it'll just be for the January 10th,
2015. Yes, Your Honor.
2015. Okay, anybody else? Nope, nope. I hear, all right, not hearing, but I'm seeing nods, no. Okay, all right, great. We'll move on to the next witness folder. All right, GBI Firearms, Voss in Wheatsel or Whitesell. Any issues on those?
Hilton and Love, man, they not in sync at all.
My understanding is that these witnesses listed are the witnesses that are going to be called. Is that correct?
Ooh,
Mr. Voss is not going to be called pursuant to the information we sent to you all a few weeks, 2 weeks ago, maybe. Mr. Whitesell is going to be called. I believe there's.
I feel you.
on
I
the
feel him
email that we
too.
sent to the
Man,
court
that's
and
got to be brutal.
Counsel for the defense. The peer reviewer and the verifier for David Voss would be called rather than Mr. Voss.
All right, and is that peer reviewer / verifier Whitesell?
No, it's actually Vanna Kelly.
Vanna Kelly? Okay.
Yes.
Is that Ms. Kelly?
Yes.
Okay. Does she have her own reports?
No. Actually, what we're doing is getting the data, the underlying data. So she verified these. And so any underlying data that she has that they may want, just in case they want
Okay.
it, we have to get that for them.
Okay.
It's unclear to me the work that I guess Miss Kelly did on this case. It's unclear to me what the work she did was, but obviously, Your Honor, there's potential for confrontation clause issues involving Miss Kelly testifying to the results.
All right, I would presume, I mean, typically when they testify, they say, I ran all the tests myself.
Right.
And obviously if they didn't, then that's going to be problematic.
Right, it would be. She looked at the evidence under the microscope herself and came to
Okay.
the same
All right,
conclusion.
so she will be testifying to her own conclusions, not to his
Not-
conclusions.
Right, hers match his, and he was the one that put out the report. She verified his by going through and looking at that physical evidence under the microscope.
Okay, but her conclusions will be based upon her own
Correct.
testing and observations.
And to my understanding, we don't have a report from Miss Kelly. If maybe she's not writing a report, I don't know, but I'm bringing it to the court's attention, the state's attention, that my understanding is we don't have a report from Miss Kelly. So if one was generated, we need that report.
That's what I was just saying. She did not generate a report, but her underlying notes and data, that is what we said we would get for them because her conclusions.
She doesn't have a separate report, but she's got notes and data, and y'all will be provided that when? Did y'all have that yet from her?
No, I spoke with the GBI last week and I'll follow up this week.
Okay. Let them know that this is an ongoing trial and they need to
I will.
Provide it ASAP and then provide that over ASAP to the defense. Okay.
Also, with respect to Agent Bernie, if we could swing back to that.
Sure.
He will likely not be testifying until the end of September, in which case any time needed, we believe, for the defense to review his analysis of the April 26th incident would have, we believe that rather than having him testify 2 different dates for those, for the incident here and the incident in April, would be obviated by the fact that he's gonna not be testifying until the end of September, as opposed to having him testify at the end of September and then come back 2 weeks into October. So I guess we're asking for clarification on whether or not he can just be brought in, whether that is not enough time for them to look at the additional reports that they were given last week, or was it last week? Week before? Week before last, right?
Okay, let's find out.
The issue isn't the amount of time that we had to review Agent Bernie's report about the April 28th incident. The issue is that Detective Racy already testified concerning the movements of cell phones. And and the state seems to be justifying this on some sort of cross-examination. Really, the allegation is that Mr. Winfrey was moving with the bus, and the allegation, which I strenuously deny, is that Mr. Stillwell was moving with the bus. Mr. Stillwell didn't have a cell phone, so I'm not sure what the point of any of this is in the first place, much less hearing it for a second time.
Okay.
Yes, Your Honor. During cross-examination, they challenged Detective Racy that he was not an expert and therefore that he could not testify as to what side of the tower that the phone was on, only the tower placement.
Okay.
And because it was specific as to what side of the tower it was on, that's why we asked Agent Bernie to do the analysis based on their cross-examination. I think specifically Mr. Weinstein objected that because Racy was not an expert, he could not testify to what side of the tower that the phone was actually on, which is important given the movements of where the phones were at particular times, the evening or the morning of April 26th. So that's why it became relevant for us to get Agent Bernie to do the analysis, because he can talk specifically about what side of the towers the phone was on at a particular time.
All right, which phone?
This was, it was Mr. Winfrey's phone, also the phone that we're identifying as Dolly White or Max or Max's phone. There may be about 3 or 4 other phones that I can't just recall off of the top of my head, but all these individuals were ascended upon the compound, which is where they started, and followed the bus all the way up to the hotel.
Okay.
And then went down to the studio after.
Okay. And does anybody identify a phone as one belonging to any of these co-defendants?
Not.
I can't get this to go back to.
Some more silence going on. People can't get their stuff together. Love and Hilton been going at it today.
Hang on.
Sorry.
Man, Love and Hilton has been going back and forth. Just look at them. Not on the same page. I don't know. Ever since Hilton came back from that trip with Fonnie Willis, man, she done stepped up a little bit. She got a little feisty. You know what I'm saying? A little feisty.
All right, go ahead.
Mhm.
Only phone that he analyzed from these defendants here will be Mr. Williams' phone, because Mr. Williams' phone, we had that plotted that he was in Baton Rouge at the time of this, which was consistent with what some of the testimony.
Okay, so tell me why we need to hear from and we may, but tell me why we need to hear from Mr. Burney about the side of the tower that other people not on trial hear.
Because it's a part of the conspiracy, and it corroborates what other people said about the movement and where everyone was at the time. And because they challenged it so much that we can only say that this is where the tower was, but with no more information.
Look at Miss Love ready to grab the mic.
Okay, and was there testimony, whether there were cell phones for these people or not, was there testimony that X, Y, or Z co-defendant on trial now was with this crowd?
Nope.
We believe that some testimony will come in soon that Shannon Stillwell, although we did not have his cell phone,
Right.
that Shannon Stillwell was present at the time, but it has not come in yet.
Okay, all right. So then, with regard to that incident, Mr. Burney's testimony should be on the narrow issue of, I analyzed these cell phones and I can say that it was this side of the cell tower. But we won't need, I would think, to go through, I don't know, but did Detective Gracie give sort of the overview of here's how we know all of this anyway, and here's what, you know?
Correct,
Okay,
yes.
so we won't have to go through all of that again. You can just cut to the chase of, yeah, I know all of that stuff too, and here's what else I know.
Yes.
Okay,
Yes.
that works. All right, so moving back to,
Can I ask you a question?
yeah,
Does that exclude then Mr. Williams, who's in another state at the time? We're not going to hear about that again.
I mean,
Am I correct?
are y'all gonna bring that up again?
Because that
Yes,
was testified
but
to.
in the sense that he received that document and he plotted that as well. Yes, but we don't have to go into the details of it. But I think it's part and parcel of what was happening that night
All right, hang
that
on.
they challenged.
Hang on. Did anybody from the defense challenge the legitimacy of Detective Gracie's conclusion that Mr. Williams' cell phone was in a whole other state?
I agreed with it.
Okay, then if there was no challenge to that, that shouldn't need to come up again,
Exactly. Don't bring it up.
right?
Can we ask him whether or not he plotted that phone? Because if he's going to talk about some of the records, we think it's important that at least the jurors know he didn't.
Yeah, I
didn't
mean,
come with the same.
yeah, if it's like that could be like a one question.
Yes.
Yes, and it was in somewhere else entirely, which I would think, Mr. Steele, at least you would like. Okay. Well, that part certainly wouldn't. So you, okay. All right. That is what I said. Okay, so back to the two firearms examiners who are going to be Kelly and Whitesell, where we can move on from that. Silence is yes here. Okay, so next is Officer Zaffa. Looks like, is this one of the crime scene techs?
He's the responding officer to the January 22nd, 2015 shooting at 1007 Hill Street that we talked about earlier.
Any issues with this?
And you're right. I think it's actually Officer Z Atha.
Oh,
yes.
Okay, there's
And
no
I
space
changed it,
between
yeah,
those
and
two.
And
Officer Alpha. Okay, thanks. Any issues on those photos, images? Are y'all just looking at these now? Okay.
My concern is I don't have any statements from any witnesses. I have the officer responding, but we'll see the next witness that you have on your list. We'll see if there's any more information that we're supposed to get.
we have the police report, Your Honor, that we've provided, and then we provided, at least for this one incident, will be Miss Reed, which is the victim in the case. And so that is what we intend on introducing.
And is there a statement of the alleged victim? That's what I
Her
was.
statements are reflected in the report, to the extent that she gave on site.
I doubt if they can hear her, that y'all just gonna have to pull that mic back over.
Her statements are reflected and memorialized in the reports that were written and provided to the defense.
Okay.
Just so we're clear, my understanding is that the allegation is her home was shot up multiple times. And so we do not have any written statement or any taped statement by any detective, taken by any detective, given by this alleged victim. And so that's what we're asking about. We understand that statements may be memorialized in a report, but we are specifically asking about tape statements, written statements.
Not a police report.
Your Honor, we'll double check, but the answer be no. Whatever her statements is contained with what she told the responding officer and he put in his report.
Police report is not
This
evidence,
was way
man.
back before body cam was typical, so that wouldn't be unusual. All right. If y'all find something else, obviously provide it, but no, that to their best belief at this point, no, there's not anything. You have everything that there is. Okay, so I'm assuming that other than that concern, there aren't any issues with these pictures that are included, since I hadn't heard any objections directed to those. Is that fair? Fair. Okay, thank you. All right, next is Sanders. I'm not sure what CST stands for, but crime scene tech Sanders. Very good. Also lots of pictures and images of their walking through the crime scene and documenting it. And then the report. Any issues? All right, thank you. All right, moving on to Antrivia Smith. What is that, a video? Okay, any issue on that? Oops. It's a short video, so even if you're watching it for the first time now.
I was under the belief that they were going to introduce this video through Mr. Sledge, but
All right, hang on, and nobody can hear across the courtroom if we don't talk into the mics. I know it's annoying, but
We have it coming in through Mr. Sledge. That's why we were just pausing, because it's already been an exhibit that's identified as coming in through Mr. Sledge, but it was Ms. Smith who gave it to the police following the shooting of her apartment to show the antagonism that existed between Mr. Sledge and YSL and Mr. Watts, whom she was also seeing. So that's the reason that it's in both folders.
I would hope the questions are not articulated that way in trial, because it's Mr. Sledge arguing with another man over a girl. I don't know YSL how that fit in, but
I said,
Okay, well, that may be, it probably will. And if it's presented that way, then y'all will have some good subject matter for your cross-examination.
that there's Mr. Sledge, since it was mentioned, Mr. Sledge said, oh, no, it wasn't over a girl. We
Okay,
weren't beefing over a girl.
all right, well, they'll say whatever they're gonna say, and y'all can examine accordingly.
This is crazy,
All
man.
right, Sharon Latner.
Defense about to have a field day with this stuff.
These would be the CAD reports, I assume. So we'll hold those for tomorrow. Does that work? Okay. And tomorrow, y'all can tell me what parts of, if any, of those y'all think might be excludable as hearsay without an exception. All right. We are moving now, at least theoretically, to a different overt act, I think, right? So now we've got crime scene tech Turner. And that folder is empty, at least for me. Do y'all have something in y'all's folders for that? They're empty for y'all too? Okay, well, maybe that was just a mistake. Is there supposed to be something in that folder?
I'm gonna check. I think that you may have already.
All right, we'll come back to that one. Y'all check on that tonight.
And that may have been the ones that they told us that APD no longer existed. It may have been the ones that we identified and told the defense about. There were about 127.
From the hack from whenever
Yes,
that was?
we had asked them for the physical copies, if there were any, because they said that the digital copies did not exist.
Okay.
And so that, I think that it was Turner. It was Turner's
Okay.
photos that were those photos that we were trying to
Those
get.
were lost in that several year ago hack, it sounds like. So that's why that's empty.
That's what the photo lab
Okay.
told us.
All right, moving to.
Lies, dog.
Jenkins.
Lies, dog.
And these are just.
So they hacked into just that folder,
photos.
and it was a
Pretty
crowd strike
standard. Any objection?
situation,
on
man.
those that
That's
y'all
crazy.
anticipate? Okay. All right, Tyrone Dennis.
I don't trust it.
All right, let's walk through it kind of one by one. All right, so the first thing is what's identified as States Exhibit 71, Act 78, and then the lyrics to Bad Boy. All right, what's our objection? And this is only if this hadn't already been litigated. If it has, it has.
Mr. Williams doesn't, these are not his writings.
Okay.
Somebody, Google, I was told Google, just put them down. I'm not telling you that they're wrong, but I'm certainly not telling you they're right. But it shouldn't come in this form. This is not how Mr. Williams made a song.
Okay.
So I would be objecting to the best evidence rule, and I don't know why. I don't know if the state is planning to hand it out as an exhibit to the jurors, flash it on a screen, but I don't believe that this is proper testimony. In addition to that, Detective Dennis, for him to claim here are lyrics and here's what they mean, I don't think he has any basis. I've asked him whether he,
Okay.
when he was qualified, whether he spoke with anybody with the lyrics, how he makes the lyric. He has no idea. He's just a listener.
Okay.
So those are all but those are, I raised those objections previously when we
Alright.
were arguing.
And, sorry, go ahead. And what?
And the court stated he made a preliminary finding, the prior court, that lyrics are admissions, confessions, co-conspirator statements, and if a proper foundation is laid, then he will decide later if they come into evidence. That's
Okay.
pretty much how
Thank
it
you.
was.
All right. So the best evidence objection y'all might need to deal with.
Your Honor, we would be, as far as the displaying or the publishing of the song and the lyrics to the jury, we would likely be doing it through Mr. Williams' words as he speaks them, and we may have a accompanying, it can be typewritten, whatever, transcript of the lyrics, however it is that we intend to display it, but that we can also provide to the jury in terms of their ability to more easily hear
As a
what is being said.
demonstrative aid.
Yes, and as far as the objection as to the meaning behind certain words or lyrics, Detective Dennis would be talking based on his expertise in certain areas, particularly as a gang expert,
Mhm.
as to certain meanings or certain language. But if there isn't, if there's a different interpretation or if someone else intends it a different way, then we would submit as the area for cross-examination or a different testimony from the
Okay.
person who's seeing.
All right, well, I think that with regard to something being used as a demonstrative aid, you need to make sure it is the correct transcription of what the lyrics actually are. It does not need to be pulled off of Google. I mean, if you want to pull it off of Google, you can, but it doesn't need to look like this. And please provide it to Mr. Steele and Mr. Adams beforehand so that if there are any disputes as to what the words actually are, those can be dealt with. And then I would permit Detective Dennis, if he's been qualified as a gang expert, to say, in my expertise, this might mean XYZ. Obviously, doesn't mean that is what it means, but that's his opinion of it, which the jury can accept or not accept. It's up to them. And of course, he can be crossed as to how on earth he might know that, and all sorts of good things, I imagine.
I guess it depends on the lyric, but intention can never be discussed by an expert, a person's intention, because it's
Sure.
not beyond the ken of the
Agreed.
jury.
I mean, yeah, I wouldn't let him say, here's what Mr. Williams meant when he wrote this lyric. Just this lyric in common gang parlance, we believe means whatever. Okay. All right. All right, the next is Exhibit 72. The same, is basically the same thing. It's just another set of lyrics. Okay.
Your Honor, one other thing when we're talking about these lyrics that I think I need to bring up right now.
Okay.
I believe that, we are going to be asking for a limiting instruction.
Okay.
I don't know how the performance of music, I mean, the state is fighting us tooth and nail saying YSL is not music.
Mhm.
So I don't know how that at the same time putting out music could be in furtherance of a conspiracy. So I would think that the lyrics can only be considered in regards to the person who is the source of the lyrics and not the other people sitting here.
Judge, I think that
Mhm.
so one, we've never made the contention that YSL members do not rap. We have repeatedly asserted
Yep.
that there is that aspect of the game.
Mhm.
So that's not true at all. And I believe that the issue of who it comes in against has already been litigated. I will make certain, looking at the order that Judge Glanville has entered, but there's no limitation as to this only comes in against Mr. Williams because he's the one that said it. It's not a testimonial statement. We would argue it's at the very least a co-conspirator statement, but and at times there are adoptive admissions, at times it's a party opponent, but there are various hearsay exceptions that allow these statements in. And Judge Glanville, we're looking at the order, but I believe Judge Glanville specifically ruled that they come in as co-conspirator statements. We'll look back at the order he wrote and entered after our very, very long hearing
Okay.
on this matter.
Okay, well, y'all let me know about that. And if y'all want a limiting instruction, you can certainly propose one and I will take it under consideration. And, you know, if it's a blanket, every bit of this is a co-conspirator statement, that's one thing. If some of them are one exclusion and, one exception and some are another, I'll just have to look when I'm considering a potential limiting instruction.
And Judge, also, when we intend to enter certain statements made by certain of the defendants in that they have put a beat behind, we don't intend to play all of the words to all of these songs by any means. So we'll extract the words that we intend to introduce and make certain they're aware of those and
Okay.
tailor those to the order that has been entered in any order that rulings that the court makes.
Okay, thank you. All right, so our exhibits down through 79, also lyrics.
A lyric,
Okay,
79 is
so,
a video.
sorry, then 71 through 77 are all lyrics.
Yes.
Okay, so the ruling would be the same as to each of those. All right, so now we'll turn to 79, which I can't seem to open.
It's a picture, actually.
Okay,
I can share it, well,
okay, thank
want me to
you.
share it, Charlie?
Sure. Why is it that it shows on yours and not on mine? Okay. Okay, it's already in.
I don't think the caption.
I couldn't hear you. What'd you say?
We believe that's in already. We agree.
Okay, Mr. Steele, did you say something about Brutin?
That's what I'm reading, but no, I said the same thing as Ms. Adams.
Okay.
I cannot be 100% sure, but I
But
believe
y'all,
it's.
all right, well, if several of you over there think it is, and y'all think it might be?
The caption may not be.
Okay, any issue with the caption?
Not 100% sure. I believe it's in, or at the very least, it's been testified to. But I guess when we find the original.
All right, y'all can let us know on that one then.
Judge, did we reserve on, or in some of the 71 through 77 because we were going to check the order? Judge Glanville's order, I want to reserve on 74.
Okay, yeah,
And-
we did. We're gonna
Okay,
get the order and then come back to that.
all right, thank you.
Thank you. Sorry, y'all. Somehow everything got closed, so I'm opening it back up. Okay, so then next would be Exhibit 82. Is that already in by chance?
I don't believe it's in. I believe we've discussed it regards to another witness
Okay.
previously. I don't have any problem with it personally.
I believe we talked about this.
I
picture
think we've
yesterday.
already dealt with this. All right. State's Exhibit 83, what is it, Lima LL? Not that up on my native phonetic alphabet. I got it right. Lima. What is, I mean, I know what this is, but what does this have anything to do with?
Your Honor, that is the, I believe that is the gun, yes. That is the gun that was found at the Dunbar Center with Mr. Copeland.
All
in
right,
the
any
H&M
issue
bag.
on this?
Not if there's an appropriate testimony to it. So no, I don't anticipate any issue.
Okay. So I imagine, obviously, they'll have to establish that's what it was, but assuming that is established, that can come in. Bless you. Okay, and then 84 Lima A. Any objection?
If this is this the black and white picture, Your Honor?
No, this is a video of a club.
So this is, Your Honor, September 30th, so the night preceding the October 1st overact with Mr. Kendrick and Mr. Arnold, where Mr. Arnold gets into a fight at Magic City. This is a video of that. And that's also 84, it's 84 LL A and 84 LL.
Okay. Any issues? Evidentiary issues?
Not assuming they can lay the appropriate foundation.
Okay. So okay, LL is just a different view. Okay. So, and then there's another 84 LL
LL and then 84 LLA.
and then
Both of them
another
are-
84 LL. Maybe that's a still? I don't know.
Let me-
Oh, no, that's a gun. Maybe
So, okay.
there's a mislabeling.
There's a
maybe.
mislabel, Your Honor.
Okay. Okay, so whatever that gun is will need to be
A different label.
a different number, but I assume that's some gun that's some way tied to something.
Yes, that- that's the gun, Your Honor, that was found on Quindarius Zachary when he was at the gas station.
Alright.
That's
Okay,
Quindarius Zachary.
then we've got 85 through 90 LL. Any objection to any of those?
Well, one of them, we've already. So 85 LL is the interview of Mr. Kendrick.
Okay,
Yeah, and we've already dealt with the
Alright.
PowerPoint, which is 86.
all right.
87 as well.
We've dealt with 87 already.
Yes. 'cause
Okay.
that's-
Oh, yeah, that's, okay.
we've not dealt with 88.
88. Any objection to 88? Evidentiary objection?
I'm sure we'll be objecting to the commentary on this posting.
Well, except for the ones by Mr. Stillwell, I suppose, because so. Yeah, okay, we wouldn't have any problem taking out anything that Mr. Stillwell doesn't post.
Okay, yeah, I mean, that's gonna be done for all of these kind of Instagram-y type posts anyway, right?
Yes.
Okay. All right. Yeah,
If the state would educate me on the relevance of Mr. Stillwell's posting there,
okay.
what they
fine.
think it means, because I mean,
All right.
I'm not gleaning too much from it.
Okay, there's a relevance objection.
All right, so Judge, we are alleging that Mr. Stillwell is a member of and a participant in a criminal street gang and a criminal enterprise known as YSL. His donning of these red bandanas, one on his right hand and one over his head, and his use of welcome to be that red bee with the red heart, Day Paradise, on March 28th, 2015, during the year or the relevant time of this back and forth that was going on, are all relevant to the allegations made in the indictment. So with relevance being
Your Honor,
the bar that it is.
Hang on, don't interrupt.
I'm withdrawing.
Oh, okay.
I misspoke. I thought they were saying that someone replied to Mr. Stillwell, and I thought
Okay,
they were
no,
saying that was his
She's
post.
taking all that off.
Okay, all right, I'm good, thank you.
All right, thank you. I think that's 100% anyway, not a heart. Had to get my glasses out for that one, but
I
I think the argument would be the same. Okay, so that objection's withdrawn. Long as, yeah, you just need with all of these to take off the comments. Same with 89.
Yes.
Any issue otherwise to 89 LL or 90 LL? Well, 90 LL is not a photo, it's a video. Any objection to either of those?
Your Honor, as long as they keep my client's comment on that exhibit as well, where he
Good.
sarcastically says we beefing, mocking the idea that there's gang rivalries.
Are we talking about 90 LL?
We're talking about 89 LL, right?
Okay.
I don't actually see that.
He doesn't say. his client says, dripping through Cali with some real ends at Gotti with that red B. His client is not listed under the 6 comments that are going to be taken out.
Is there like some comment later that isn't shown maybe? Because I don't see it on this.
You're right. I think he's talking about, correct me, the first comment says at SB with the we beefing, but I don't think that that's Mr. Stillwell. That's
Okay.
the other person posting that she's beefing with him.
What's going on is
Mhm.
these comments are in dark blue on the black background, so I'm
Right.
only seeing the white. So I'm seeing my client commenting, "We beefing," which obviously would be sarcastic. He's sitting next to his friend, but now I see the blue that Okoya having her way posted that. So
Yeah. Okay. All right. How about 9DLL?
What does that have to do with RICO?
I don't know what the relevance is of.
Okay.
What is the
There's a
relevance? Thank
relevance
you.
objection to 9DLL and 403.
Judge, I think it's best if we just play this
Okay.
one.
All right, here we go.
Big B, Lil B, Slime, YSL, Crip Killer.
That's Mr. Williams's voice
We believe.
Based on.
directing
Let's not interrupt each other, please.
directing this child to throw up these gang signs. So that's what we.
So are you going to have some kind of either somebody familiar with Mr. Williams' voice to say that's him or a voice analyst to say that's him?
We would have someone that we believe is familiar enough with his voice to say that that's him.
Okay, well, we'll see.
on behalf of Mr. Stillwell, we're going to ask for a limiting instruction, if that's admitted.
All right, provide, proposed one, please.
On behalf of Mr. Williams, Your Honor, what
Mhm.
is the import of this? So I understand it's prejudicial because a person may think that a young child using what I would consider gang language with their hand signs
Mm-hmm.
may be inappropriate, but why would this matter here? The lyrics are coming in. Mr. Williams is constantly changing the letter B to, or letter C to a B. Like instead of Cleveland Avenue, Believeland Avenue, there's a whole bunch of lyrics that Judge Glanville let in. There are tattoos on Mr. Williams' body that has already come in that shows the letter B and alleged other supposed gang symbols. They have introduced, they being the court has admitted into evidence, exhibits showing things like a green snake or an emoji with a B on it. I just don't understand why the child is an important part of this mission to find the truth here. And Mr.
For real.
Williams' voice, I find it to be wholly prejudicial, and I find the probative value to be scant.
All right, let's hear from the state.
So, Your Honor, as the court is aware, the rules of evidence are rules that favor admissibility, and 403 should only be used in extreme situations. And Mr. Williams, not the state, bears the burden of showing when something is shown to be relevant, it's presumptively admissible, and he bears the burden of showing that its prejudicial effect substantially outweighs its probative value. And Mr. Williams has said nothing about the prejudicial effect of this video with his child, with Mr. Williams dictating to this child, throw up B, YSL, Crip Killer, which are all things that Mr. Williams has attempted to distance himself from throughout the entirety of this trial. He has asserted that all of this is, not real. All of this is, just a facade. And the more that the state is able to show to the jury that this is, in fact, not a
Appreciate you, the
facade or
best
not
Mama Bear.
someone hitting on Mr. Williams' designations that are not accurately pinned on him, then the stronger the state's case becomes. So our
What?
argument is that Mr. Williams has in no way shown that this video is substantially more prejudicial than probative.
All right.
Your Honor, with respect to Mr. Huey, we would also chime in on the 105 instruction, but notwithstanding that, Your Honor, can you hear me, Judge?
I can hear you. I don't think that's working, but I can hear you anyway.
Can you hear me now, Judge?
Yes.
So we would also ask for the 105 instruction on behalf of Mr. Huey, but notwithstanding that, Your Honor, this is extremely prejudicial from the standpoint of having a child
And inappropriate.
hold up these gang signs and so forth and so on, what appears to be gang signs.
Leave
And
children out of
this
this.
is going to be one of those scant and cumulative aspects of a piece of evidence that if the court allows it to come in, it's going to be drug in for the sake of its prejudicial effect. Clearly what 403 says we can't do. So I would ask the court to take that into consideration.
Okay, well, I'm certainly considering the appropriate law. Yes, sir, Mr. Steele.
There's also another, I can't find the exhibit number, but there's a video that came in over objection that Mr. Williams is doing something similar, or someone's doing something similar with a child.
All right, why don't y'all get me that and I'll consider whether there might be a cumulative issue here. But with regard to just 401, 403, it's certainly relevant, and I agree that it's prejudicial, which, case after case says most of the state's evidence is prejudicial against defendants. I don't think it's substantially more prejudicial than probative, considering part of the conspiracy they allege is preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating alignment to the enterprise and a willingness to engage in violence on its behalf. I mean, it's wildly probative to that.
And Your Honor, we're also going to ask for a Rule 105 instruction on behalf of Mr. Kendrick, and
Okay.
we echo the comments made by the others.
Okay. Yes, ma'am.
We don't believe that a 105 instruction on this type of evidence is appropriate. It's not a testimonial piece of evidence, a testimonial statement. So we would ask that a 105 instruction not be given in instances where this is the evidence being presented. And we would also submit that Jeffrey Williams is alleged to be the leader of this gang, and in having or directing this child and other children to do things like he's doing, he is, in effect, he's starting early and starting young. That is part of the state's theory in this case, that this gang recruits young children, and this is what it ends up being.
Judge, I think there was a piece of evidence that came in on, or we reviewed a child on yesterday, if I'm not mistaken, that we saw in an image. It was either posted.
Yeah, but I don't remember that being anything that the child was doing in response to somebody directing them to do it. I think it seemed like the child was, I'd be happy to look at it again, because that's not specifically what I was looking at it for then. But if that's what y'all are thinking about,
Well, that's one at least that immediately came to my memory.
And do you recall that child was doing that in response to somebody directing them?
I'm not sure if there was sound associated with that particular image, but it was certainly at the direction of an adult, and then the child was.
Was it Mr. Williams?
I believe it was.
Yes, Judge, it was. It was the one of the two videos that you saw on yesterday, and when you listen to the sound, it's exactly the same thing. The child is being directed, and in fact, it's the same child.
Okay.
He says Big B, Little B. He doesn't say Crip Killer. He doesn't say YSL.
All right, that is not cumulative, if that's the only one that y'all had in mind. So that's, I'm overruling those objections. Okay. I think that takes care of that. Witnesses exhibits, at least for now. Martinez Arnold. I see there's a plea agreement in that one also. On same grounds as before. Is there anything in particular on that one? I know there was. This isn't the same one we talked about before, is it?
No.
Mr. Sledge.
Okay.
It will be similar ground. You know, he's testifying, so why do we need a plea agreement? And the state wants to put it in, my understanding. And it would be continuing witness because it's a statement, and he could testify to whatever, and then he can get impeached.
All right, well, continuing witness is only about whether something goes out to the jury or not.
Correct.
So that's not relevant to whether it actually comes in or not. And then it's the state's intention to use this only if you need to impeach him as to something? Okay.
Correct, Your Honor. And if he's truthful, then we don't need to accept, I mean, if he's truthful, then we don't need to go and show and introduce this as an exhibit. And I'm assuming they're talking about the factual acknowledgments, not the,
I don't know.
not the conviction
I
itself.
don't know. Let's find out. Are you talking about the factual acknowledgements?
I am talking about the factual acknowledgement, and then there would have to be a proper purpose for the guilty plea, which there could be one, but I didn't hear it yet.
All right, is there anything about the factual acknowledgements here? Like, I know that last one y'all were saying, I don't think this person has any firsthand knowledge. Is there anything like that I need to look at in particular? Okay. All right. And so for these people, you just intend to have them admit they pled guilty? Okay, so this wouldn't be relevant at all unless they say, no, I didn't, or no, I never asserted
like-
that fact, or
so-
this would be.
So right, or that he was forced, or he didn't
Right.
know what he was doing.
Right.
I think the certified conviction might actually be proper evidence. I need to think about that, but as far as the other stuff that they're
I
talking
mean,
about,
yeah, and you can certainly, I guess, tender that if you want to.
yeah. But
Normally-
the other information is only, as we said earlier, if someone isn't truthful in the stand.
Right, okay. Thank you. All right, the next item in there, I can't open, so I don't know what that is, but if y'all can open it and you know what it is and don't have an objection, then it doesn't matter that I can't open it.
Your Honor, we're talking about the third one down?
I was talking about the second one down because I don't know what that is. The one labeled like NT Fulton CODA and then some numbers. Oh, okay. Don't know why I can't open it, but we've already reviewed that one. Or no?
So this is a transcript of an interview with Mr. Arnold, and there is no need to enter this or use it unless we need to impeach him.
Okay, and I assume it's a certified copy that y'all would use if need be. I mean, I guess it wouldn't have to be, but.
It's not certified?
Okay.
You mean of the transcript?
Yeah.
It's not certified. It's just a.
It's a hallway conversation.
Say that again.
It's a hallway conversation. It's not-
Hallway
it's not in
conversation.
court.
It's a
not like it-
130-page transcript of a conversation.
Oh,
Interview.
it's not a transcript of the guilty plea.
Right, no, it's an
Okay,
interview.
thank you.
It's an interview. That's what I was saying. It's an
Okay.
interview.
It's a transcript of an interview, which you don't assume you'll be using unless you have to refresh his
Impeach.
recollection or impeach him.
Right,
Okay.
that's what I was saying.
All right, no problem. How about this next thing labeled recording?
And let me just say, I don't know what Mr. Arnold's going to testify to or not testify to. To the extent that the state is ever planning on just playing I understand targeted impeachment,
Mhm.
but and if I've fallen short of expectations, I apologize, but I have not reviewed this transcript for any extraneous, irrelevant,
Okay.
prejudicial.
And yeah,
things.
and thank you. Y'all don't intend to wholesale use that. If you did, that would be a problem, needs to be targeted. So yeah, just regular old trial evidence. Okay, thank you. All right, and this next thing, which is maybe some sort of a musical recording.
Itself.
Ah, okay. I opened it up and it shows a musical note. I guess that's just my media player. Okay. And then this last thing is a picture.
Photograph, yes.
Any issues on this one? No? Okay, moving on to Officer Munson then. Looks like there's another set of crime scene pictures, maybe. And a crime scene report. Couple of crime scene reports. Any issues on those?
Don't anticipate any issues with the crime scene photos.
Okay, thank you. All right, moving on to Jennings Kilgore. We are almost to the bottom of this grouping of 30. This seems to be a ballistics expert.
NIBIN expert.
A what expert?
NIBIN, National
Okay.
Institute of Ballistics.
Okay.
Immigration.
He is a ballistics expert with a
Ni-
particular.
NIBIN is different.
It's a
Yeah.
big time one, right?
It's the one right before. It's not the actual firearms examiner. So it's a step before. It's a comparison to see if if these have the same characteristics.
All right, anyway, anybody have an issue with the evidence that's going to come in with this person?
I'm sorry, what is this, this is under, I'm trying to find out specifically where it's under the NIBIN reports. I don't know if I'm pronouncing that right. NIBIN charts. There's a document labeled Operation Planters
Okay.
NIBIN chart.
Okay, I can't open that one either, but
Yes, and that's a summary of
okay.
NIBIN matches that were.
I'm having trouble seeing it in detail, but
Yeah, maybe because the black on the blue is a little hard to read. And we're all old and have old eyes. So is the question just kind of like, what does that say?
what is that?
So those are the chart with the black on the blue. That one is showing that there were 5 shell casings from a particular scene. The black on the blue is the address.
Okay.
The red lines are matches to other addresses where shell casings consistent with the firearms at the previous address were found.
Okay.
And there was, I think that we served in discovery, but I don't think we included in this list of exhibits. There is also an ATF NIBIN examiner that we didn't have in here that they also examined some of these shell casings from different sites. Both Kilgore at the Atlanta Police Department and ATF were all working in conjunction with one another. So
Okay.
there's one more person that we'll be adding to that, but we'll let them know well before we.
All right, well, if they're gonna say the same thing, we don't need them both.
We won't have.
All right, so with regard to this kind of chart, I guess, now that you know what it is there an objection?
I have one. Okay. Well, here's the problem, Your Honor. And before you were involved in this case, a lot of these prior incidents were Detective Dennis took the stand and the state brought out an easel and they wrote down all these different case numbers and they went through them real quick.
Okay.
On January 26th, 2015, there was a shooting at 841 Smith Street. I'm just making that
Yeah.
up. Okay. And in this, and as a gang investigator, I determined that that was part of this beef. Okay. We for a lot of these incidents, we have not heard from any witnesses that collected shell casings. There's been no chain of evidence. There's been no testimony about the collection of evidence.
Okay.
So this is just like coming in without any basis or any foundation, and it would all be hearsay.
All right, is
And
he,
violate the Confrontation Clause as
okay,
well.
is he gonna be testifying that he received the shell casings from each of these and did the exams, or that other person from ATF that you mentioned, or how is this gonna get used?
When shell casings are collected, the first person that does that comparison is either Kilgore at APD or they're taken down to ATF to do that comparison.
Mhm.
What Kilgore or the ATF NIBIN person would say is this shell casing here was consistent with or had the same general class characteristics as this shell casing over here that was found at this scene, and produce what we call a hit.
Right, so is Kilgore gonna be able to testify that for each of those blue boxes, he did an examination or comparison, and that's what he came up with?
Yes, for everyone that we have a match for, either Kilgore or ATF, or Kilgore or ATF did that initial NIBIN comparison. I'm not sure if what the objection is, if we're not gonna have him talking about something somebody else did. If that's.
Okay, so I think one of the objections is that thus far, we have not heard shell casings were collected from this firearm scene and provided to Kilgore, and then Kilgore obviously would say, yeah, I got them and I did this evaluation. Is that all of that foundation is gonna have been laid in evidence by the time he gets here to testify to this?
Yes, that's why we have the crime scene technicians coming up, talking about what they collected.
So it sounds like by the time we get to this, that will have been done.
Be a two-way connection though. It can't just be, we collected, I'm using an example. We collected, certainly we've had the crime scene, or we will have had the crime scene technician, I believe, from the January 10th incident.
Mhm.
So we'll know what was collected, and it was sent to Kilgore and it was sent to NIBIN, and we get that. But if they're going to say, well, it matches another crime scene, the expert in a lab can't say that unless we know. They can say, I guess, presumably it matched another bullet in the database or something like that. But unless there's a link to an individual crime scene, yes, we collected this and it matches up, that's still based on hearsay. Kilgore or whoever the expert in the lab would be would be testifying based on hearsay about where that other ballistic evidence was collected from, unless we hear from the person who collected the evidence.
And we would. So I don't know why, I don't know why we're arguing at this
We're
level.
not, we're not arguing, we're trying to clarify. So for instance, and I can't see them, but the very top two on there, you know, they apparently say, okay, this crime scene A and crime scene B. We will have, and this person, Kilgore, will be able to say, I did a comparison of bullets from crime scene A and bullets from crime scene B, and they're consistent with having been shot from the same gun or something similar. The question on the floor is, okay, will we have already heard not only the chain of custody for Kilgore getting the crime scene A bullets, but the chain of custody for Kilgore getting the crime scene B bullets?
Yes, so we would not have, yes, all of the foundation. I don't think chain of custody, like, you know, specific, like every link in the chain would be necessary, considering we would have the crime scene technician who would have collected it. We would have the testimony that when the crime scene technician has collected it, it comes to my department, my being Kilgore. This is the case number 150261534. And I compared it to case number X.
Okay, so we will have both, just so I make sure I'm understanding you. We will have a crime scene tech from crime scene B say, I collected all of this and I gave it to the crime lab, or whom, I don't know if this is.
I put it in, I put it in evidence.
I put it in the, you know, box or whatever they do. And then we'll have Kilgore say, here's the way evidence gets to me, and this got to me that way.
Yes.
Okay, does
Yes.
that answer your question? I mean, I guess it's yet to be determined whether we will hear all of that evidence, but the objection is going to be, if we don't hear all of that evidence, he can't testify to this. So do you understand that?
I'm sorry, Judge. The objection is that
if we don't hear the foundation that is both crime scene A tech giving the evidence to Kilgore and crime scene B tech collecting and giving the evidence to Kilgore, and then Kilgore is saying, I got them both in the regular course and I compared them, here's my conclusion, that there's going to be an objection that he can't testify about crime scene B.
And to make certain, looking at the witnesses that we had initially put up, what we can do is add the 10 witnesses from each of those crime scenes that are on this list to make certain that we have each of those links included as
Sounds
evidence.
like that's going to have to happen. Now, it does not need to be, I don't think, a whole as if this were the crime on trial.
It would just be,
it can just be,
hi,
I'm a
I'm
crime
witness
scene
number
tech.
1 through 10 that I'm adding on. I collected
I
this
went
one.
to this crime scene at the state. I collected
Right.
this evidence. I gave it to whomever.
Right.
Which should take 10
minutes.
Okay. All right. She plans to now do all of that. Unless y'all want to stipulate that those bullets got to the crime lab in the normal course from whatever crime scene, which I don't see happening. So, okay. All right. So anything else with regard to Kilgore's, the evidence that would come in through Kilgore? All right. Then our witness number 30 on this list is Underwood. Is Underwood also a NIBIN expert?
She's one of our and detectives and gang experts in this case.
Okay.
And she actually may have been the one, she was an ATF task force agent, and she also would have been instrumental in taking some of the evidence over to the task force versus APD's ballistics lab where Kilgore worked
Okay,
to have it tested over there.
okay. Any issues with her evidence?
Yes, because it's going to be repetitive. She is an APD officer. And she's going to be supposedly or potentially the same treadmill of information about YSL and if gang, and this is what the policy is of the City of Atlanta Police, why we qualify people in a gang, and we've heard it from Detective Belknap, Detective Gaither, Detective Dennis. They have 5 gang experts allegedly from the same exact, they work together.
Is this a
So she
gang
is-
expert?
That's what I said.
She may be
she's-
a gang expert, but is she going to testify as a gang expert?
I don't anticipate getting into anything overlapping. And actually, we were, before this last conversation, thinking of not calling her at all.
But, okay, so she would be chain of custody only?
Some chain of custody. And at this point, I don't anticipate calling her as another expert. But as far as the gang experts are concerned, Your Honor, I just point out that what we've done is announce to the court and to each of the defendants that our gang experts would not be talking about overlapping pieces of information. Every expert was talking about a different point in time as to their knowledge.
Okay.
Detective Underwood had an earlier knowledge of this particular street gang than did Detective Dennis. Detective Belknap testified to a different slice of time.
Okay.
Detective Dennis and Gaither were 2 people who worked as partners during the same period of time. But when we are alleging that this is a street gang that has existed from 2012 up until 2022, you know, during the time of this
Right.
indictment and even afterwards, and we have every step of the way had cross-examination questions and the rebuttal assertion that this is not a gang, this is just a music label, and none of what you see really amounts to what the state is saying. To have gang experts who have an expertise in particular cuts of time that the gang existed is not cumulative. And the very fact that some of what they say overlaps doesn't in any way make what they're testifying about so cumulative.
I understand. All right, so has this person already testified as a gang expert?
She's not, she's just been
Okay.
qualified as one.
Okay, so you do not anticipate having her testify in her gang expertise role, just as custodian of whatever this evidence and getting it from one place to another then, is that right?
At this point, like we said, at first we were, and then we were
Okay.
like,
All right, and I would think that if for whatever reason you decide that's something you think you need to do, let's address that, because I don't think we need to hear, and I hear you saying we haven't heard the same thing, but we don't certainly moving forward need to hear the same thing. So, okay, that's clear. Thank you.
Your Honor, as the state is announcing that she's just going to be, Investigator Underwood is just going to be a kind of custodian of, or transferring evidence from one place to another, I assume that the operation planner's NIBIN chart and the operation planner's NIBIN leads new chart will not be introduced through her?
Well, none of it's the same or substantially similar to what will be introduced through Kilgore.
I agree. I just noticed
Okay.
that in the
I-
folder.
Yeah, I mean, they do, again, I don't know why, but I can't open a lot of these on this computer, but is that the same thing or is that something different?
It's a colorful picture showing like a flow chart involving the information that Kilgore has.
Generally the same?
It's all the same information. It's just presented.
It's
in
more
a-
colorful?
Yes.
I mean, pick one or the other. Okay. All right. Is it easier to read than the other one?
it is.
Okay, well, you can always switch the witnesses that you were going to use that for, but yeah, we don't want to see it twice, but okay. All right, that gets us through our first 30 bucket.
We haven't
No, it
done Mr.
doesn't.
Sprinkle.
Well, yes, other than Mr. Sprinkle that everybody wanted to come back to. All right. Trying to just look back through at things we need to revisit or visit for the first time. Okay, so I think this is a good place for us to stop today. And then, tomorrow, other than the potential hearsay and CAD reports, which we can take up, we can either move to the next 30 and do the same thing with regard to them, because they're going to have to be done at some point when the jury is out. Or y'all don't seem to want to reach the wiretap stuff yet, but as quickly as y'all can specifically identify that and get it to the defense, then we can get to that. I think it'll be easier once they actually have targeted information about that. Yes, sir.
Know why necessarily, but the state specifically identified jail calls for my client as they've stated, which is, I believe, 13 or 14. I've reviewed those.
We're right. Okay, so tomorrow we can tackle
right.
those. Okay.
And I'm just warning everyone, other people, not in a, I'll just say it affects.
Alerting everyone.
I'm alerting everyone that it affects more than just my client.
Okay, so everyone might want to take a close look at those before tomorrow. Okay, anything anybody needs to put on the record, make suggestions about for how to be efficient tomorrow, anything like that?
Your Honor, it's State's Exhibit number 55W, which would target the child with the hand signals.
Okay,
If you can, it's 55W has been shown to the jury.
would it be easy for somebody to pull it up on screen for me? And is this just a still photo or is this a video?
A short video.
Okay,
It was played for the jury.
all right. Is Mr. Kokomo going to play that for us, or I don't see him anymore? I think the state's going to try to find it.
Yesterday's, I just don't remember that, but it's one that was played months ago. Yeah, you come outside the house.
Okay.
I have another matter while the state is
All right.
helping us. Can I just tell you a case?
Mhm.
Okay, so I believe that my concern about when it's dealing with the RICO conspiracy in Brutin, and then the person in custody is giving a statement, confrontation clause statement, talking about the enterprise, let's say.
Okay.
I have found that my argument has been rejected. And this is the 11th Circuit, United States versus Espinosa, ESPINOZA. It's 635 Fed FED period APPX 739. It's in Division B as in Barry. And it's 11th Circuit 2015. And the 11th Circuit found that we reject the defendant's argument that because the confessional statements may be proof that a RICO enterprise existed, which is a necessary element of the RICO conspiracy charge against both defendants, the statements trigger a confrontation right under Brutin. If the defendants were correct, then any incriminating statement made by one non-testifying co-conspirator would be inadmissible against the other, whether or not the statement facially incriminated the other co-defendant. Brutin's narrow exception to the general rule of admissibility does not extend this far. That's what I found.
All right.
So it's only triggers what we were saying earlier, Mr. Stillwell, Mr. Williams, but I was saying YSL or the
Right.
crew, and I cannot find a case that supports that.
All right, I appreciate you bringing that to the court's attention. Every attorney has a duty to be candid with the court, even if the case law does not favor the argument they wish to make. And so I appreciate that, because I have to say, unfortunately, everybody doesn't do that. So thank you for doing that. Okay, do we have this ready to play? Oh, okay.
Shout out to everybody that's still rocking with us. They're about to end court in a minute, but they're going to do some last minute stuff here. But thank you all so much for watching the live today. Appreciate you.
That's a successful lifestyle. Oh yeah. Real sleep, aka bleeding, nigga. Yeah. Man, what mud? We do this every day. Kitchen, yeah. I ain't gonna put you on the camera. Go on the trench, man. Yeah. Want to give a special shout out to my niggas. Big B. Little baby roll
Yeah, that's actually the one I was thinking about. I mean, that child starts doing all that stuff unprompted and then maybe gets encouraged to do a little bit more, but I don't think that that shows the same thing as the other piece of evidence that we were talking about. So thanks, but my ruling stands on that.
Can we have a continuing objection if I need?
You may. All right, I'll see everybody at 9 in the morning.
Judge,
Yes.
one thing we did reserve, if you recall, waiting for the order from Judge Glanville on witness number 26, that's Dennis, particularly number 74. We can deal with that tomorrow easily, though.
Great. Dennis, number 74. Mr. Harvey, was that one of the lyrics issues or was that a different item?
Well, it's lyrics, but it's a video.
Okay,
Thank you.
thank you.
The Gossip Girls, man, they real serious, ain't they? Okay, court is adjourned for today. I am I'm gonna be honest with you guys, man. I'm totally disgusted at the fact that the state is presenting children in this particular trial on camera, throwing up gang signs. It's already inappropriate that the children is throwing up gang signs in the first place, which we totally understand that for sure. Let me just say that first and foremost. But to submit this into some evidence in this trial that is unrelated to anything that they're being indicted about is absolutely disgusting. I'm disgusted with the state and the judge even allowing this to even take place. So that's probably why I'm a little bit like on the chill side right now. Because to me, you don't mess with children. You do not mess with kids. You don't involve kids. I don't care what they did on camera. You don't involve children into evidence and make it relevant to anything. Like seriously. Like leave children alone, man. Leave children alone. They don't have anything to do with this case. Even what we just saw, that video has nothing to do with anything related to RICO or anything. I'm glad that Brian still said, well, can I have a continuous objection? Because that video is inappropriate already. And the fact that you're allowing inappropriate evidence with children in this case is absolutely disgusting. Like you're willing to go that low. You don't have no evidence. Your case is so messed up, state, that you're willing to go as low as putting kids, a video of a child being instructed to throw up gang signs, and the fact that you hear a voice telling this child to do it, and you're saying that we believe that it's Young Thug's voice. And when the judge say, well, you have a voice expert to know about Young Thug's voice, and they like, yeah, we have someone that can testify that they know Young Thug's voice through and through. And the defense is like, we don't understand how this is even relevant to anything. Well, I guess it has something to do with the state is saying it. Guess it has something to do with the fact that they are representing this particular gang. Or you do not mess with kids, man. I'm talking about in stuff like this. Kids are being, man, it's so much stuff that's happening to kids. When y'all get a chance, I want y'all to look up WPATH. WPATH is World Professional Association of Transgender Health. And I want you, there are files of this organization that do surgical procedures on kids, man. You don't mess with kids. I don't care if that kid was instructed. That's a child. That young child don't know what they're doing. They're only doing what they're told to do. And you're willing to put that into evidence just to confirm that was Young Thug's voice telling him to do that? You are disgusting to me, man. Leave children alone, dog. When that happened, I kind of checked out, y'all. I'm gonna be real with you. Everything they kept saying was poo-poo to me, straight up. You don't mess with kids. You don't have any type of ballistics, forensic evidence experts to say that this shell casing is the same as this shell casing with this particular gun. You don't have anything, man. So you're just reaching for anything by putting kids into this. So now when the jury come in and they see this evidence or see this particular evidence in this trial, they're going to see a child putting up gangs. You think that's not prejudicial? Unbelievable, man. This is the most diabolical piece of crap I done seen from the state. I mean, the state is already some liars, man. But to go down to this road, we want to put a video of a child. It's just a child. It's just a child. I'm talking about the video that they played that they put into evidence. It's just this child. And allegedly Young Thug's voice saying, Crip Killer, YSL. And he throwing up every time he says something, he throw up a gang sign. All because you want to say, we want to establish the fact that this is Young Thug's voice. And we're going to have someone to come in to show evidence or to confirm that that is Young Thug's voice. To prove what exactly? You're trying to prove that he's the leader of a YSL gang. And this is the way you're going to do it? You already have enough evidence, if you have evidence at all, which you probably don't. You already have enough evidence to show that he was in charge of YSL. I mean, hey, YSL is a record label. Who you think it belonged to? Now you want to say he's the leader of a gang. You're trying to establish that this was a gang. You're trying to establish some street beef. But you're going to use this as a way to establish it. You don't mess with kids. Kids are off limits. Period. You do not mess with kids. This is no reason for that to come into play at all whatsoever. There's no reason for it. There's absolutely no reason. Love is evil, man. That is some evil stuff right there. Straight up. I checked out, y'all. I ain't gonna lie. I kind of checked out a little bit when it came to that point. But once again, man, shout out to everybody that was rocking. You know what I'm saying? She, Lee, and Time, and Flesh of the Gods. Man, Flesh of the Gods, I really appreciate you coming through. I've been given a clean slate. Says kids are innocent. Exactly. Kids are off limits. Period, man. Period. You do not mess with kids. You just don't. All right. Breaking it down with B said, love has no morals, win by any means necessary. Exactly. This is crazy. This is absolutely insane. Children are off limits unless they're directly affected. Absolutely. Absolutely, man. The day of court is over. This again, they're starting off with half days and things of that nature. I did not hear a time frame from the judge on when they're going to start tomorrow. Hopefully tomorrow is somewhat better. I'm not sure. But what I'm going to do is I wanted to talk about Brian Steele this morning. He appeared before the Supreme Court, with a different case, State versus Riley, and he's representing Riley. And I wanted to showcase Brian Steele, the GOAT, when it comes to lawyers, man. In this particular case, criminal defense lawyers. Because he did an excellent job before the Supreme Court, and it was just him and him alone. He had no counsel, he had no assistant with him. He went to the Supreme Court this morning by himself, presented his oral argument, which is about defective indictments, which is another argument that he made about this YSL trial. And so we're going to go ahead and showcase that. So what I'm going to do is I'm going to drop a video on it tonight, probably in the next couple hours or so, and drop a video thumbnail and showcase Brian Steele, and you'll be able to get a chance to watch it and tonight. All right, so I'm about to go ahead and do that. They're saying court is in the morning at 9. All right, so court is in the morning at 9. I'm gonna be honest with you guys. I don't know, man. It depends on how I'm feeling tomorrow morning. I'm like Woody. Depends on how I feel. Depends on how I feel that I might go ahead and stream it. If I do stream it, it might be a little bit later than 9. I do have to take care of some stuff early in the morning for myself. So, but I'll let you all know for sure. All right. Flesh of the God said I had a good time hanging with y'all today. Stay up, family. I appreciate that, man. We're a good small channel, small fish, big pond. Yeah. So it is what it is, man. I appreciate it, dog, so much. Don Cato says salute. The caveat I see is she's got you making her argument for her thing. This case isn't even about what you're seeing. It presents behind it the Lord's Tucker of today. Yeah. Yes. It's basically I just don't understand. Man, they lost me with the kids, man. They lost me with the kids, man. I mean, it's already bad that the kids is throwing up signs, but putting that into evidence to make Young Thug become this leader of this gang or whatever. I don't. Man, it's so many ways to skin a cat. That's just not one of them. But again, we're gonna go ahead and call it. I'm gonna go ahead and get this video together for you guys tonight. Drop that video, man. Y'all go ahead and like, subscribe, and share this to the people. Thank you all so much once again for supporting the channel. I appreciate it with the likes. And I'm gonna go ahead and get it popping. Get this video done for you all. And I'll see you all tonight in the chat, man. I'm gonna premiere it so that way we all can talk about it, interact with it together. All right. I like that interaction with y'all. I do. I really, really do. So until tonight, man, I'll talk to y'all later. And thank you all so much again for getting me over 1,000 subscribers. I appreciate it for sure. Thank you all so much for the support, for the love. We are growing, and we're gonna continue to grow. All right. I'll talk to you all later, man. Peace.
Baby, I'm just too jiggy. Better know I brought that with me. Case they get too iffy. Baby, don't stress, don't sweat it. Put it all on my daddy. Know how I'm coming. And they know what we hate. Around through that left side, low end. All of mine need more wins. If you got beef, don't come out. Cause my young hitter might go in. Uptown GN. Working all through my weekend. Hoping these don't show out. Cause all of my hitters too deep in. With a boy, I'm so ashamed. Ain't worried about long as my money and my green. Baby, I ain't got work tomorrow. Tell me what the business is. Ain't about no club hop. I'm trying to start some businesses. Shorty, you thought it was, they better know it's not that. Talking all that online, they knowing that it's not fact. Sliding through my hood, I make maneuvers like a Uber, baby. Got a 10-year plan, these can't tell what they doing lately. And I'm way too clean, I'm Listerine, I thought they been knew it. All in my lungs, I got my red cup full of that hint fluid. Young middle Mac, I'm swinging that leg, I'm banging that do or die. And I ain't that bleedly before I get crucified. Living in my bloodline, this place in my family tree. How the they pressed, I did my best out of what they handed me. Straight out of that country, know my shawty thick as human air. And I need not mention no extensions, that's human hair. Boy, we grew in there. Around through that left side, low end. All of mine need more wins. If you got beef, don't